Yes, Mr. Gupta.
Item 1 and 2.
Item number 1.
My lord, item 1 and 2 are my applications. My lord, I am for the petitioner. My lord, the petitioner has expired, my lord, on 17th of May 2026. My lord, I am praying 7 days time to take necessary steps for substitution of the legal heirs, my lord, of the petitioner.
This was released by a coordinate bench,
Justice,
my lord,
yes,
and
my
after
lord.
that it has been assigned.
And it calls for the petitioner. Submits that the petitioner has expired. He wishes to. You want to bring the LRs on record?
Ma- Yes, my lord. My lord, we have executed one power of attorney, my lord.
He wishes to bring the LRs on record. Let necessary steps be taken.
Out of the
List after 4 weeks.
Yes.
Number 3.
This is a section application. This matter has been settled between the parties. I'm paying for withdrawal.
Take down.
Instruction.
Petitioner states that the matter has been amicably settled. Instruction to withdraw the present petition. It's taken on record. The present petition stands dismissed as withdrawn. Interim order, if any, stands.
Item number 4 and 5, withdraw.
Item number 4
and 5.
Item number 5.
3, 4, 5.
Item number 6.
Six is there 29A application. My lord had heard Mr. Shatarup Banerjee and my lord Mr. Ratnakar Banerjee is leading me. My lord recollect me lord, my lord I adjourn this matter on the ground that we have challenged the order passed by the learned arbitrators rejecting our claim of section 30. My lord that the arbitration is terminated in view of the settlement. Now my lord the day when my lord the matter was adjourned by your lordship, my lord we had filed. We have got the number. Now it is being listed. We have mentioned thrice before Justice Omnarayan Rai. My lord, Justice Rai has assured that the matter is fixed before the learned arbitrator on 21st.
For
So,
final
my lord,
arguments, my lord.
For final arguments.
My lord, from 2022, the
Rai
arbitration
has
is going on, my lord. 227,
assured
my
my
lord.
lord that he will, my lord, upgrade the matter, my lord, before 21st. My lord, we had mentioned upon giving notice to them. So, my lord, in that view of the matter, my lord, it was mentioned thrice, more than thrice, my lord, before
Prior
the
to
vacation.
the vacation, my lord.
Yes, prior to the vacation. Vacation, we are third day only. So, my lord,
And after
kindly
vacation,
keep
they
it
have
any day after 21st, so that, my lord, we can get it hard, because otherwise, my lord, section 30, my lord, cannot adjudicate here. So, my lord, on that count, it was adjourned last day.
All right.
My lord, 227, my lord, 227 is filed, my lord. That is a separate proceeding, my lord. Extension may be given, my lord, and after, if they get a stay, my lord, the arbitration will be stayed, my lord.
We'll have it after.
Yes, my lord.
We'll have it
After 21st, yes. No point, my lord. No point.
And learned counsel for the respondent states that simply re-notify. At the request of the party, let this matter be rested on. When do you want? After 21st?
My lord, after 25th, on 25th, my lord.
24th.
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 Much after.
Can it be after? Can it be on the 30th?
30th.
Oh, no,
No,
no.
not
3
30th.
0 24th absent difficulty. I believe my lord takes up other matters on the
29th.
29th. Very good. 29th.
Item number 7.
This is my section 29A application, Your Lordship. My lord, the mandate has expired on 18th of May. I have filed this application on 14th. My lord, on 15th, Your Lordship. My lord, everything has been done, my lord. It is only we are awaiting the final award, Your Lordship. The learned arbitrator has undergone a heart surgery. He's recovered,
other
Your
side.
Lordship. Lord,
Actually, Mr. Shubir Pal was appearing. We have served. Affidavit of service already filed. We have served it on the 18th of May itself. That's the affidavit of service.
on the earlier occasions also, they have appeared and they have given consent, Your Lordship. These are recorded in the orders.
So you get them, pass it over.
My
Get them, pass over.
Item number 8.
My application under section 29A. Here, my lord, the matter is in the stage of final arguments. Claimant has, my lord, completed the arguments. Respondent is, my lord, well underway in making arguments.
Come at 12.
Yes, my lord.
Come at 12.
My lord.
Yes.
If I may just give your lordship the dates, my lord. Here, my lord, there were two previous arbitral tribunals constituted, my lord. One by an order of 13 December 2019, who withdrew from the reference, my lord.
So 13th December, the first arbitrator was appointed.
Yes, my lord. First arbitrator appointed on 13 December 2019. He withdrew from the reference by a letter of 19th June 2021.
Then
Thereafter, my lord, lordships by an order of 20th July 2021 was pleased to terminate the mandate of the erstwhile arbitrator and to appoint the new arbitrator on the new arbitrator. The new arbitrator, my lord, unfortunately, he expired on 27th July 2022. Thereafter, by the order dated 1st September 2022, my lords were pleased to appoint the present arbitral tribunal.
the date of the order?
1st September 2022. My lord, the present learned arbitrator accepted his appointment by a letter of 28th September 2022. And the first sitting before him, 12th September 2022, my lord, the first sitting was held before the present learned tribunal. My lord, thereafter the pleadings were completed on 16th November 2022. 1 year expired, my lord, on 16th November 2023. 6 months consent, my lord, extension, that expired on 15th May 2024. Now, my lord, this is a voluminous matter. In fact, one of the claimant's witnesses had also expired, my lord. He filed his affidavit of evidence, but before he could be called to the stand and depose, he expired. So, my lord, there has been some impediments in this matter, my lord. So, and there's a counterclaim as well. So, on 3 occasions, my lord, previously we've had to trouble your lordship under 29A, my lord. First order, my lord, was 8th July 2024. Granting 6 months extension from 15th May 2024 up to 15th November 2024. Thereafter, second order under 29A, my lord, was 18th November 2024, granting 1 year extension from 18th November 2024, expiring on 18th November 2025. And my lord, lastly, there was an order of
For 1 year, right?
for 1 year, my lord. And then the third order, my lord, under 29A was 26th November 2025, granting 6 months extension from 26th November 2025 up to 26th May 2026, which is when, my lord, the mandate has now expired. My lord, the prayers are at page 19. We have prayed for a further 6 months, my lord. As I said, my lord, the respondent is well underway in making its arguments. After that, the claimant is only to rejoin.
Take down. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that this court-wide order dated 13/12/2019 appointed Mr. Malay Kumar Ghosh as the sole arbitrator to adjudicate the dispute between the parties. Full stop. After conducting few hearings, Mr. Malay Kumar Ghosh, by letter dated 19/6/2021, resigned and had withdrawn from the office of the arbitrator. Full stop. Hence, this court-wide order dated 27/2021, appointed Shyama Prasad Sarkar as a substitute arbitrator. Full stop. However, on 27/7/2022, Mr. Shyama Prasad Sarkar expired. Full stop. This court again, by order dated 1/9/2022, appointed Mr. Utpal Bose as the sole arbitrator. Full stop. This court-wide order dated 8/7/2024, 18/11/2024, and 26/11/2025, had extended the mandate of the arbitral tribunal by 6 months, 1 year, and 6 months. Full stop. The mandate of the arbitral tribunal has expired on 26/5/2026. Full stop. Learned counsel for the petitioner states that the matter is at the stage of final hearing, and the learned arbitrator has conducted more than how
Beg your
many
pardon?
sittings?
Number of sittings is 54 sittings so far.
More than 54 sittings. Full stop. Upon consideration of the materials placed on record and the submission advanced by the learned counsel for the respondent states that she has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record and the submission advanced by the counsel for the parties, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting its proceedings. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 6 months from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to complete the arbitral proceedings and publish the award within the extended time period. Full stop. With the aforesaid directions, the present petition stands disposed of.
I'm grateful, my lord. Only one thing I may indicate, my lord. 53 sittings have been convened so far. The 54th is scheduled this evening. I'm grateful, my lord.
Number 9. Lordship, item number 9, Your Lordship, I appear for the petitioner. This is my application under 29A. Your Lordship, a retired justice of the Calcutta High Court was appointed as the arbitrator on 8th April 2024, and thereafter he entered appearance. First sitting was held on 16th May 2024.
When was the arbitrator appointed?
8th April 2024, page 81, my lord, is the order. Thereafter, he entered appearance, and Your Lordship, the first sitting was held on 16th May 2024. Pleadings got completed in this proceeding only on 5th of December 2024. So, my lord, 1 year from that date expired. Your Lordship, sometime on 8th of December, 5th of December 2025.
Give me the date.
Fifth-
Pleading
Yes,
completed.
pleadings completed on 5th of December 2024.
With the consent of the parties.
Yes, 6 months extension was granted. With consent, page 85. That 6 months expired on 4th of June 2024. Your Lordship, we have filed the application within time. Your Lordship, after we have filed our affidavit of evidence, we are for the claimant. The respondent took out an application under section 31.
Yes.
On the basis of the pleadings made by the respondent, we have also taken out a section 31. So section 31 is being heard now. In the meantime, Your Lordship, talks of settlement has been going on from the month of April 2026. So Your Lordship, section 31 is still required to be disposed of, and thereafter, Your Lordship, the examination will start. So Your Lordship, I was seeking for 12 months extension to complete the arbitration proceeding. Your Lordship will find the 6 months extension at page 85.
I take the petitioner. Same kar dena, first paragraph. This court, by order dated 8/4/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 5/12/2024. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended for 6 months till 4/6/2024. Full stop. 4/6/2025. It should be 2025, right? 2025.
No. My Lord, 1 year from the date of completion of pleadings expired on 5th of December 2025. Then
20
6 months extension till 4th of June 2026.
4th of June 2026.
Yes.
6 months till 4th of June 2026. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Parties further state that they are exploring the possibilities of an amicable settlement. Full stop. Upon consideration of the material placed on record and the submissions made by the learned counsel for the party, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 8 months from today. The sole arbitrator is requested to make all reasonable endeavors to complete the proceedings, arbitral proceedings, and publish the award within the extended time period. With the aforesaid direction, the presentation stands.
Lordship, instead of 8 months, can it be till 10 months? Lordship? Because we are in the stage of 31. That's right.
Come back again.
Grateful, my Lord. Grateful.
Yes, sir.
Not 10.
Yes.
Can you give password for 10 minutes?
Why, what happened? Yesterday also
Senior counsel is.
same matter. Yesterday. Not today.
It's only 10 minutes password.
Friday, Friday. Not
11.
My Lord, my application under
yes.
section 11 for appointment of arbitrator, the petitioner
Yes. Yes. 11. 10. Not today.
10, not today. 11.
petition is engaged in the business of supplying.
Yes. Yes.
The petition is engaged in the business of supplying heavy vehicle drivers and conductors to the respondent being South Bengal State Transport Corporation. And 3 agreements were entered into between the parties. Those are from pages 15 to 19. And work orders were issued. Thereafter, upon satisfactory performance by the petitioner, it was further extended, and thereafter bills were raised for the supplies. Now the respondent has withheld the bills for the period from February 21 till February 22, 2022 for a sum of rupees 88 lakhs and odd. I'm aggrieved by that. All the agreements contain arbitration clauses. My Lord, if my Lord comes to the arbitration clauses, my Lord, the first agreement is at page 11.
Starts from 2017, 23rd February 2017.
2017. My Lord, Arbitration agreement is at page 14 of this agreement.
Page-
Clause 16. Page 14, clause 16. In the event of any dispute arising out of this agreement shall be referred to the sole arbitrator to be nominated by the chairman, SBSTC. The award of the arbitrator shall be final and binding upon both the parties and cannot be challenged. The venue of the arbitration shall be at Durgapur or Belghori office of the corporation, and the arbitration proceedings shall be in accordance with the provisions of the Arbitration Act. Now, my lord, pursuant thereto,
So after this agreement. when
work
was
order was issued
when
in respect of this agreement. That's at page 15 on 13th of September 2017.
September.
Now, my lord, the second agreement is at page 19. That's dated 26th of February 2018. And the arbitration clause is at page 21, clause 16, the same arbitration clause, which was incorporated in the first agreement. At the bottom, clause 16. The language is same.
Then
The third agreement is at page 23, 5th February 2019, and the arbitration clause is at page 26, same clause, clause 16. Now, my lord, owing to non-payment for the period for raising of the bills for the period from February 21 till February 2022 for a sum of rupees 88 lakhs and odd, I'm aggrieved. I'm praying for appointment of arbitrator in respect of all the three agreements, because these are interrelated, same nature of agreement, and the arbitration clause is same.
I have two objections, my lord.
Yes.
Firstly, my lord, your lordship will see the contracts referred to, these are separate contracts. Work order separate, agreement separate. Not a composite contract or continuation of the earlier contract. Because it is not a running account which is going on. He cannot claim the benefit of a running account because the question of limitation will come. The second point is limitation, my lord, that if work is executed in 2017 or 18, question of limitation will come. I know that is the issue of 16 or in the reference, but kindly records this submission and regarding invocation, how he can invoke in respect of different agreements, unless the court consolidates, these are separate agreements. Page 11 is one, my lord, page 15, then page 19, these are separate.
separate agreement, sir.
My
Agreement
lord.
separate.
Although they refer to the same tender notice,
My lord,
referring to the same tender notice, but agreement is different. Page 17 is the second work order. Your lordship will see it refers to the tender notice dated 30th of May 2017, which was there in the previous one also, but separate contract. First one is at page 15. That also refers to the same tender, but separate work order, separate agreement.
Well, may I? My lord, first of all, the bank statements are from pages 91 to 120, where the payments have been made. Payments are not bifurcated. Those are all ad hoc payments in respect of all the three agreements. The payments cannot be bifurcated. And my lord, the last payment was made at page 120 on 30th of March 2022. And regarding limitation, the section 21 notice was invoked on 14th of January 2025. That is well within the period of limitation. That's at page 85. Page 85 is the notice under section 21, and the last payment, that is at page 120, the last entry, 30th of March 2022.
They invoke jointly at page 85 under section 21, but the agreements even different.
Arising out of the same
My
tender.
lord,
Tender was same.
Tender
Tender
was
was same. Now, after that, one work order is given for a particular period. After that, referring to the previous one,
Can be
another
clubbed.
work order. my lord.
Can be clubbed.
Because the payments have not been made.
Kindly not keep this point open for me, my lord, because I'll be taking this point because otherwise they'll take that plea of my lord, a continuous running account. I say these are separate my lord, contracts. There was no running, separate bills were raised. So question of limitation will come. Kindly not keep these 2 points open.
My lord, I'm relying upon the authority of this honorable court.
Hey, Gopal.
Over here, there were two agreements. One is license and another is service agreement. Over there also, the respondent took the same point as my learned friend is taking, that there should be two separate references. My lord, I'll place page 6, paragraph 2. In the present case, the jural relationship created between the respondent on the one hand and the petitioner separately on the other pertain to enjoyment of the sales and premises. My lord, page 6, subpara 2. My lord, may I? In the present case, the jural relationship licensee created between the respondent on the one hand and the petitioner separately on the other pertain to enjoyment of the sales and premises. The said jural relationship holds together on a common fabric the leave and license agreement, which confers rights on the respondent to enjoy the property, and the service agreement, which provides the services for such enjoyment to effectively take place. Thus, the common underlying jural relationship vis-a-vis the property between the parties is the unifying factor which juxtaposes the rights flowing from the two agreements. Over here also, all the agreements refer to a single tender, my lord. Hence, I find that in the event there is a separate reference to arbitration with regard to two agreements where the set of transactions and the developments leading to the disputes would be common, there is ample scope of unnecessary multiplicity of proceedings and a conflict of hours which ultimately would not ensure to the benefit of either party. My lord, in my case also, the payments have been made on ad hoc basis.
It's not
Not-
applicable. This is entirely different set of facts altogether. It's for enjoyment of a property where there's a lease and license agreement. This is entirely different. Hey, these are all separate agreements for separate work orders for which you have probably raised a composite.
As because the claim, the payments were made On-
Payments are being made to
on ad
a-
hoc basis, not
to an account. How
to an
can-
account, my lord.
account. So that is your account.
Yes, my lord.
So you can't say that the payment is being made on ad hoc basis on based on these.
But
bills.
my lord, my humble prayer is that it emanates from the same tender, and the nature of work is same, and the arbitration agreement is sacrosanct. All the three agreements. That's
As
my
far as
humble
the
prayer.
arbitration agreement is concerned, it's fine. You have a arbitration clause also, but then the work orders which have been issued are different work orders for which you should have raised different.
My lord, this will lead to multiplicity of proceedings, as because this has been a continuing process. This has been a continuing process, and I pray for appointment in a single reference, my lord.
Let them take that plea then over there.
My lord.
Take that plea.
I can take
for the
that.
arbitrator. Take that. The present petition has been filed under section 11(6) of the Arbitration and Conciliation Act, seeking constitution of an arbitral tribunal comprising of a sole arbitrator to adjudicate the dispute between the parties. Full stop. Petitioner is the sole proprietorship concerned, engaged in the business of supplying manpower to the respondent. Full stop. The parties initially entered into an agreement dated 23rd February 2017 for the supply of heavy vehicle drivers and conductors to the respondent corporation for operating its route buses, pursuant to which a work order dated 13/9/2017 was issued. Full stop. Thereafter, similar agreements were executed between the parties on 26/2/2018 and 5/2/2019, right?
My lord.
5/2/2019. Full stop. The said contractual agreements were extended from time to time. Full stop. It is further stated that the rates payable under the contract was revised and enhanced by letter dated 24/9/2019. Learned counsel for the petitioner submits that where's the amount mentioned in your notice?
My
Yeah,
lord, amount is mentioned in
An
the
amount, the learned counsel for the petitioner submits that
Page
a sum of
85.
rupees 88,00719 remains outstanding and payable by the respondent towards the services rendered by the petitioner.
My lord, the page
And
86,
today I got it.
para 9.
Raising invoices and issuing repeated reminders, the respondents have failed and neglected to release the said amount due to the petitioner. Full stop. Agreed by such non-payment of admitted dues, the petitioner invoked the arbitration clause, contained being clause number 16 of the agreement dated 23/2/2017, 26/2/2018, and 5/2/2019 by issuing a notice dated 14/1/2025 under section 21 of the Arbitration and Conciliation Act 1996. Full stop. Despite receipt of the said notice, the respondent neither liquidated the outstanding dues nor took any steps in accordance with the agreed procedure for appointment of the arbitrator. Full stop. In these circumstances, the petitioner has preferred the present petition. Full stop. Learned counsel for the respondent states that learned counsel for the respondent has twofold objection to the present petition. First, he states that the contracts entered into between the parties are separate contracts and that the work orders which have been issued under those contracts are separate work orders. Full stop. He further points out that this is one. Second is
Claim is barred by limitation, laws of limitation,
Yeah.
not live claims.
that's these two.
These two.
Secondly, he states that the claims which are being raised here are barred by
Yeah,
limitation. Full stop. Having heard the counsel for the parties and having produced the materials placed on record, this court is satisfied that this court is satisfied that prima facie there exists an agreement between the parties bearing clause 16 in the said agreements as the arbitration clause. Full stop. It is also noted that the said agreements, all the three agreements dated 23/2/2017, 26/2/2018, and 5/2/2019 are arising out of a single tender dated issued by the government of West Bengal by GO number 1502
May 30.
WT-TR00 ये यहाँ से लेना होगा ये page 11 dated 24/2017. Full stop. All the agreements have been executed in terms of the said tender and thus are comprising out of the same contract which has been extended from time to time in furtherance of the nature of the work being executed by the petitioner. Full stop. This court holds that the valid arbitration agreement exists between the parties by virtue of clause 16 of the agreements dated 23/2/2017, 26/2/2018, and 5/2/2019. Full stop. Further, wide communications dated 13/9/2018, 5/9/2019, 13/9/2021, 28/12/2021. The said agreements were extended from time to time. Full stop. There is a claim for outstanding dues of the respondent. There's a claim for the outstanding dues of the petitioner which has been refused by the respondents. Thus, leading to a dispute between the parties. Full stop. In proceedings under section 11 of the Act, the scope of the examination is confined to the existence of an valid arbitration agreement between the parties. Full stop. Accordingly, this court is satisfied that a valid agreement exists between the parties and the present case is a fit case for reference to arbitration. Full stop. Accordingly, this court appoints who? Give me a name. We can appoint anybody.
Nandu, Arun Kumar Boral ke koi? By agreement, Mr. Arun Kumar Boral, not his.
Mr. Arun Kumar Bora, just give the details. So and so is appointed as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. All questions relating to arbitrability, maintainability, admissibility of the claim, limitation, and all other issues are kept open to be adjudicated by the learned sole arbitrator. Full stop. The learned arbitrator shall enter reference upon compliance with section 12(5) of the Arbitration and Conciliation Act. The remuneration shall be fixed in accordance with the 4th schedule of the said act. Full stop. Communication. Yes, Mr.
But I am for the petition, my lord. On the last occasion on 6th May 2026, my lord, has taken up the matter, my lord, directed for affidavits. Till date, they have not filed the opposition.
Your Lordship, I am for the respondent and we need extension of time for filing AO.
Why?
As the opposite party is not available for signing the documents.
I'll impose the cost.
And he's a very senior citizen, you know.
So what?
Kindly allow us
So what?
time.
We have already given you time,
Yes, Your Lordship, but
subject to payment of cost of 50,000.
that
Do you think this is
give
a?
3 days time at least. If
You
Your
think-
Lordship permit.
I think it's your right to
No,
get an extension.
No, but it is just a humble prayer to
Abide by the orders passed by this court.
yes, Lordship, and if you allow.
Last opportunity. Learned counsel for the respondent speaks and is granted further time of 1 week as last opportunity to file his affidavit in opposition. Affidavit in opposition, right? That was
Yes. And also reply.
reply to the same if any within 1 week after, list after 4 weeks.
Developed.
My lord, item number 13, before my learned senior friend starts, my lord, we have not, the client, over telephone, the client has asked me to oppose this matter, my lord. But we have not received, the client has not received the section 11 application, my lord. I am praying if a copy may be given to us and
My lord,
with
it
the
was-
supplement, with the supplementary affidavit, my lord. Only we got the 5 pages of the supplementary affidavit, but the loan agreement has not been given to us. Only 10 days time, my lord, be given. I will come back.
But section 11 application asking for appointment of
Well, there
arbitrator.
Maybe some,
My lord, whatever, my lord,
Dispute the agreement.
my lord, not the agreement,
Where's your
but
file?
my lord, there is,
Where's your file?
my lord, I do not have the documents, my lord, right
I
now.
will not hear you.
My lord, kindly
I
give
will
me,
not hear you. I will not give you any time.
my lord,
Where's your file? Why you have come to the court?
my lord,
without the file?
over telephone, I have been instructed to
Where
oppose
is
this.
your file?
Well, I have not, the client has not received the section 11 application. That is what I am praying before your lordship.
my lord, it was served. I have the affidavit of service on earlier
Affidavit of service has been filed. If your client is not giving you the details, it's none of the
My
concern
lord,
of the
can
court.
it be, my lord,
I'm sorry, I'll appoint the arbitrator.
my lord, only thing, my lord,
I will not hear you and I'll record this also.
my lord, kindly, may I just,
Sorry, sir.
my lord, the
This
notice
is no
was,
way to come and stand in the court.
my lord, the
Your
notice,
client has told you. What is this? The client has received everything. And I'm not concerned if your client has not given you the directions.
my lord, the notice has been given to my client from them, stating that there is a settlement give a settlement within 90 days, my lord.
My lord, that it is
Kindly
respect
please-
of my
no,
lord
no,
separate
my lord,
account.
My lord, kindly, no, it is with regard to this loan agreement.
No, my
My
lord,
lord,
there,
I will show the notice. I will show
my
you
lord,
the
there was, my lord, 2 agreement. One is respect of my lord car and one is respect of my lord personal loan. My lord, one is settled. That is my lord, the car loan is settled. My lord, this is in respect of my lord personal loan. In earlier occasion, my lord, at the time of hearing appointment of arbitrator, they appeared and opposed. When my lord straight away question was asked in respect of the validity of the agreement, the same question was reiterated. They are not objecting, they are not disputing the agreement, but my lord, they are disputing the appointment of arbitrator. My lord, they are not paying the installment since long, and my lord, they are enjoying my lord the loan facility.
Give him the copy.
Yes, my lord. Hear him now, my lord. I am
The copy.
my lord, the supplementary affidavit and my lord affidavit of service, my lord.
Supplementary affidavit.
Client ke সব দেয়া আছে।
আমার মাইক কষ্ট আমি
আরে তোমাকে দিয়ে দিচ্ছি, that's not an issue, but don't make
By the
submission that
petitioner
your
is taken
client
out
has
the
not received.
Affidavit of service also taken up.
My lord, today I
Learned
filed
counsel
my lord
for the
supplementary
respondent.
affidavit and affidavit of
Learned
service.
counsel for the respondent states that he had not received copy of the section 11 petition. The same is supplied to him in court. Let this matter be listed after 10 days.
My lord, the affidavit of service I filed, it states that item delivered to addressee. Specific averment is there.
I will do it in my cost.
That's why a separate issue my learned friend is asking for.
Stand in my court without papers.
My lord, I apologize, my lord, over telephone.
And even if you have some communication, take a printout and stand in the court.
My lord, I apologize.
Don't show me the phone.
My lord, I apologize.
My lord, 10 days, my lord. Get one, man.
Now 14.
My lord, I am being led by Mr. Sanjanwala.
In the matter, my lords. This is for appointment of an arbitrator. And the other side is not objecting to an appointment as such.
Where is the other side?
My lord, they were not there before vacation. Mr. Auturu Banerjee was appearing in this matter. But
He had appeared last time he was here.
they sought time because I believe he will not appear. I am not too sure.
You have to serve them, madam.
It has all been served. Opposition's affidavits are complete. They were there the last time also.
So what do you want me to do? Hear the matter and pass an order.
My lord,
Get the other side. Not today.
no.
Fifteen.
Your Lordship, I am for the petitioner. I'm led by Miss Manika, Your Lordship. I'm praying for accommodation, Your Lordship. Her mother is admitted in the hospital, Your Lordship.
All right. Proxy counsel so and so appears and states that the mother of the main arguing counsel is hospitalized. He prays for an adjournment on the said ground. Let this matter be listed after 4 weeks. Or 2 weeks after 2 weeks.
Sixteen.
But my application for appointment of an arbitrator.
Responded. Sorry?
Time for opposition against this. May I indicate?
Opposition for what? Are you disputing the agreement?
No agreement, but it's a partnership agreement.
Whatever it is, are you disputing the agreement? Are you disputing the clause?
I have filed a suit. You were just civil court challenging the legality validity of this partnership deed. My case is that the signature is not genuine.
Yes.
May I indicate, there's a partnership deed. There is no dispute insofar as the partners are concerned.
Yes.
The deed is at page 25. Lordship may see, there are 3 partners from, Lordship may see from the cost title itself.
Yes.
3 partners in the partnership firm.
Yes.
The petitioner was inducted as a partner by way of the last deed, which is of 1st July 2024 at page 25. That deed contains an arbitration clause. Now, there are disputes between the parties with regard to furnishing of accounts, with regard to shares in the partnership firm. I invoked the arbitration clause by a notice of 20th March. In response to that, the other partners say that the signatures appearing of some other parties, some other persons who retired from the partnership firm by way of this deed are forged. They don't say that their signatures per se are forged. They respond to my notice by saying this, and then they go and file a suit challenging the deed. Now, Lordship may straight away come to the suit that they have filed.
Page 72.
Page 72 is the suit.
Yes.
Now, kindly takes the averment at page 74.
So whatever it is, suit has been filed, right?
I'm sorry, my lord.
Rightly, wrongly, suit has
Suit has been filed. Yes, rightly, right. I can't shy away from that. Now, my lord, kindly, suit is relevant. But at page 74, paragraph 5, Lordship may kindly come. Accordingly, on or about 1st day of July 2024, another deed of partnership was made and executed by and between Rakesh Chaudhary, plaintiff number 2, Mrs. Uma Devi Kejriwal, who's the petitioner here, the defendant number 2, Mr. Romit Mojumdar, pro forma defendant here. Romit Mojumdar and Rakesh Chaudhary. These are the respondents in this application. And Srimati Sita Kejriwal, defendant number 1, describing as retiring partner. So what they say in paragraph number 5, the deed was executed between such and such persons. Thereafter, in paragraph 6 onwards, they say that they have come to learn that the signatures appearing of the other persons in the deed of partnership are forged. Now, kindly straight away comes to the reliefs, page 78. Page 70, Lordship, is there?
Whatever it is. Anyway. Let them file the reply.
Right.
Take down the petitioner has the present application has been filed under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of an arbitrator for adjudication of the disputes and differences arising out of and in connection with the deed of partnership What is the date? Deed of partnership dated 1st
July
July
2024.
relating to the partnership from MS CRISPR Biopharma Inc. ISPR. Learned counsel for the petitioner submits that the dispute and differences have arisen between the parties in relation to the affairs and management of the partnership firm. Full stop. It is contended that the respondents have denied the petitioner access to the accounts and records of the partnership, withheld financial information, excluded the petitioner from participation in the management of the business, and failed to render accounts and share profit in accordance with the terms of the partnership deed. Learned counsel for the petitioner further submits that clause 25 of the deed of partnership contains an arbitration clause, and the reference to the said dispute is arbitrable. Full stop. It is further submitted that a notice dated 23/2026 was issued in terms of section 21 of the Arbitration Conciliation Act 1996, invoking the arbitration clause and calling upon the respondents to take steps in terms of the agreed procedure for constitution of the arbitral tribunal. Full stop. It is further contended that the respondents replied to the said notice and no arbitrator was nominated by them in accordance with the arbitration agreement. Learned counsel for the respondent contend inter alia that the deed of partnership dated 1st July 2024 is not genuine and the signatures appearing thereof are disputed. Full stop. He further contends that a civil suit Page 78.
Page 72, my lord. Title suit number 807 of 2026.
Title
7 or
suit
2.
number 802 or 7. What is it?
But 2 or 7, I also can't
What is it, sir? 802 or
802, 802.
802
2 of 2026.
of 2026 has been instituted, touching upon the dispute between the parties. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 8 weeks. File your reply.
Great. But 4 weeks for opposition and another 4 weeks
2
for
weeks. 2 weeks for reply.
Great.
Appearance to the appearance to 17.
At 17, I appear for the petitioner. It has been served, but I would, my lord, pray to come back, my lord, next week. My lord, we found out, my lord, certain documents which have been, my lord, pleaded inadvertently were missed out, my lord, in the, my lord, petition. So I need to disclose those documents by way of a supplementary affidavit. I'll serve Mr. Shah and I'll come back next week, my lord.
What are those documents?
My lord, the documents,
What you have mentioned and is not there.
my lord, at paragraph 54, page 32, my lord, I have referred to certain annexures, my lord, some of which have been missed out inadvertently. That is one set of, my lord, documents.
Page 32.
My lord, page 32, paragraph 54.
Yes.
And my lord, post filing this section 9, there is, my lord, another application which was taken out, my lord, which has
So
to be,
your annexure U does not contain all this.
that does not contain all, my lord. It should have contained, my lord, 5 documents. My lord, 2 are there, my lord, 3 missing, my lord. That has to be, my lord, incorporated, my lord, by way of a supplementary affidavit. And there are two or three, my lord, subsequent documents post filing, which, my lord, would be germane for adjudication. So I wish to, my lord, bring on record that as well. Kindly permits us to use a supplementary. I shall serve and come back, my lord.
Yes, yes, yes. Learned counsel for the petitioner submits that he has inadvertently missed out documents as mentioned in annexure U. Full stop. He seeks and is granted liberty to file a supplementary affidavit, bringing on record the documents which have been missed out, as well as which documents you
My
want,
lord, a further document, my lord, post filing, my lord, subsequent events.
as well as some documents which he states have come to his knowledge after the filing of the present petition.
His lordship used, my lord, annex
Germane to the adjudication of the present petition. That
since lordship referred to only annexure U, the other my lord, document which is not there but referred as annexure was annexure Z. My lord, annexure U and annexure Z.
annexure U and
My lord, may I come back on sir?
of the present dispute can also be filed by the petitioner. के अलावा मुझे लगा
My lord, 17th, if lordship permits us to come back, my lord, next week, Wednesday, my lord, 7 days hence.
in a period of what's the urgency? Then here,
My lord, it's a section 9 application. I want some urgent interim relief, my lord. Lordship would consider whether I'm entitled to it. I don't want my lord, lordship to my lord visit that, my lord, issue.
period of 2 weeks.
Great.
Entire matter is now before the Supreme Court in an admitted, my lord, SLB.
What is here?
I shall make my
I shall, my lord, try and convince your lordship why lordship can, my lord, pass an interim order, my lord. Because my lord, right of my lord audience would be the first court.
List after 3 weeks.
Very well.
My lord, kindly permits us to come back after 2 weeks, my lord, 24th.
3 weeks. Nothing is going to happen. 3 weeks.
My lord, I only have one request, my lord. 3 weeks takes us to first. First, I am not there. Maybe, my lord, 30th, my lord, in that case, my lord.
1st of July. So we'll have it on the 6th of July. 6th of July, Monday.
6th of July.
6th of July.
Lordship,
For item 18, I'm appearing on instruction, my lord, for the respondent, even though nothing has been served upon me, my lord.
Lordship, may I?
Served upon him. Why?
Lordship, this is my application. The application is not, the service of the application is not yet completed, Lordship.
Learned counsel for the petitioner states that the respondents have still not been served. She seeks and is granted 2
Lordship,
weeks time to serve upon the respondents. List after 4 weeks.
Lordship, my lord, because I'm appearing, my lord, without the Vakalatnama being filed, I'm undertaking to file the same within this week, my lord. The Lordship allows me.
You file your Vakalatnama whenever
Very
you
good. Yes, yes. Grateful, my lord.
Item 19 is my section 15 application, Your Lordship. Your Lordship recalls this was filed as a 11-6 when Your Lordship had correctly observed that it has to be a 14. Now the facts of this case are
Lordship, in this case, we have after going through the we have seeks instruction from the client, and to cut short, we have also suggested for fresh appointment of an arbitrator. But the difficulty is they have seek some time for evaluation of our suggestion. So kindly keep this matter in the next week, any day next week, so that we can.
The only difficulty is I do not oppose that. The only difficulty is in the interregnum, they are proceeding with the arbitral proceedings. There is a notice. Next date is on 23rd of June, if I recall correctly. Your Lordship kindly allows me. When is the next date? My only apprehension is in the interregnum, they should not.
Even if it is on 23rd June, then if in next week, I think any day next week can.
Yes, when is it? 23rd June. We'll have it before that.
19th.
Any day before 19th, then.
Yes, we can have it any day prior to that.
Prior to that, exactly.
19th we'll have
When?
19th.
19th.
19th is a Friday.
19th is a
We'll
Friday.
have
It would be 18th, you know.
22nd.
18 is execution day.
22nd.
22nd. Grateful Lordship.
The arbitration is fixed on 19th, right? The arbitral sitting is on 19th.
It's on the 19th.
Yes. So it
Then
has
let's
to be
say
prior to that.
Then 17th.
17th, Your Lordship. Very good.
Grateful
Lordship. Deeply obliged.
I thought that's on the 23rd.
Lordship, I by mistake said 23rd, Lordship. It's 19th.
I'm obliged.
20.
Lord, I'm for the applicant in Lord IAGA 2. Lord, I am an award holder in Millard and arbitration proceedings. The award date on Millard filed an application seeking stay of the award, Millard. By an order dated Millard 22nd of
On the
January.
other side.
Millard, we have served them the notice. Affidavit of service.
What is it? This application is for?
Millard, there was a direction to Millard to submit bank guarantee.
Yes.
Because Millard, we had invoked the cost portion which was awarded to us.
Yes.
That bank guarantee has expired on 4th of March 2026. We went to the register March 2026. We went to the register with the bank guarantee dated 6th of March 2026. Since there was a
Show me the order, the first order.
first order is Millard at page 9 is the order starts Millard
22nd January.
22nd January.
Show the relevant.
Relevant portion is at Millard page 14. The award holder will furnish a bank guarantee of rupees 55 lakhs cover the cost component direction C with the register original side of this code with a fortnight from today. This direction is subject to the award holder receiving 2920 crores for the award holder date in the course of the day. Not pursuant to that, we have submitted.
Yeah.
And the last bank guarantee had expired on 4th of March 2025.
When did you submit?
First one is Millard, it is at page Millard
5th of
18.
March.
Yes. And then, my lord, the last bank guarantee is at page 83. My lord, should be said, my lord, in the interregnum, my lord, their section 34 has been dismissed. They have preferred an appeal before the Honorable Division Bench, my lord. The Honorable Division Bench has
It's a delay of 1 day.
it was 2 days. 4th of March expires, 6th of March. We have, and the claim period is up to, my lord, 4th of March 2027 at page 84.
Take down. This application has been taken on by the respondent, praying for condemnation of the delay in furnishing the renewed bank guarantee before the registrar original side of this court. Full stop. By an order dated 22/1/2024, this court had directed the respondent to furnish a bank guarantee for a sum of rupees 55 lakhs. Full stop. Pursuant thereto, the respondent furnished a bank guarantee dated 5/3/2024 for the said amount. Full stop. The value of the said bank guarantee expired on 4/3/2026. Full stop. Learned counsel appearing for the respondent submits that the bank guarantee has since been renewed. Full stop. However, there has been a delay of 2 days in depositing the renewed bank guarantee with the registrar original side of this court. Full stop. It is submitted that the delay was neither deliberate nor intentional and has occurred due to administrative reasons. Full stop. Reasons. Full stop. The respondent accordingly prays for condemnation of the delay for the acceptance of the renewed bank guarantee. Respondent. Having considered the submission advanced by the council and noting the delay is only of 2 days and that the bank guarantee has already been renewed, this court is satisfied that sufficient cause has been shown by the respondent for condemnation of the delay in furnishing the bank guarantee. Full stop. Thus, this court condones the delay of 2 days in furnishing the renewed bank guarantee. Full stop. The registrar original side is directed to accept the renewed bank guarantee on record. Full stop. Provided the same is deposited within 1 week from today. Full stop. No further orders required. Application is first. Here it is.
Great.
Please.
$21.
For the respondent.
BSNL.
BSNL.
Today, I am praying to your lordship. I take up this matter next week. I have personal difficulty.
Next.
Get next week, any day, any convenient.
Not this.
$22.
My lord, this is my application. My lord will kindly recall, this is regarding MSME proceedings, my lord. We have filed a section 34 and 36(2). In 34, we have deposited 75% of the awarded amount in August 2025. On that basis, my lord, my section 34 was entertained. Then the court wanted to decide whether any further amount should be directed to be deposited over and above 75%. Then we made submission that we are entitled to unconditional stay on 2 grounds. One is that natural justice was violated under the second proviso of section 34(2), that natural justice was violated, and second is that the award is nullity. We had placed those notifications. As per the notification, the MSME Council constitutes of 5 members. The award had been passed by 4 members. My lord had directed us given us liberty to file a supplementary affidavit to get the notification from the MSME Council Konkan as to what was the constitution of the MSME Council at the time of making of the award. We have written to them and we have also prepared supplementary affidavit. My lord, now what happened? After we filed the supplementary, in the meantime, the interim order which was granted to us has been extended 5 times or 4 times, my lord, in the presence of the other side. After my lord's order, they are saying that we have not deposited 75% amount, awarded amount as mandated under the. Kindly take the award.
Lordship, I do not wish to interfere, my learned senior friend. This is only with respect to extension of the interim order, the
Yes,
today's
ma'am.
application.
It has been extended time and again. Last time an objection was raised. That is why my.
Yes, ma'am, I'm not, I'm just, Lordship, the point, basic point over here is the pre-deposit. This is a award from the MSME Facilitation Center. The pre-deposit, there is a condition of pre-deposit as per section 19 of the MSME Act. Lordship's own order, if I may place.
This has been placed, my lord. I have not completed my submission, my lord. This order was placed last time.
Let her make a
Oh,
submission.
Lordship.
My lord will kindly take the award, which may I place it from the section 36(2).
Yes.
The relevant portion of the award at page 34.
So have you filed your supplementary affidavit?
Yes, my lord. I wish to.
What is the quorum in that?
My lord, as per this, on the date the award was made, the quorum were there is five members. Yes, my lord.
And it's a valid award.
No, the award has been made by 4 people, my lord. That was my ground.
Oh, the supplementary affidavit would have brought that the details on record.
Yes, my lord. May I place the supplementary affidavit? Kindly come to paragraph, page 10, my lord, of the supplementary affidavit.
Yes.
As on 11th December 2009, the MSME Council consisted of 5 members. Page 10,
Yes.
Annexure A.
Yes. In exercise of the power conferred by section
Yes, my lord.
2021.
May I just place the section? Before I place this notification, my lord, can I just place section 20 and 21 of the MSME Act? The section 20 gives the power to establish the council, and such establishment has to be as specified in notification. So if I may read it, the state government shall by notification establish one or more micro small enterprise council at such places exercising such jurisdiction and for such areas as may be specified in notification. So the establishment has to be by notification. Kindly take section 21.
So it can be 3 to 5.
Lordship.
My lord.
Lordship.
The Act gives them power to do 3 to 5.
Yes.
Now, after they exercise that power and constitute a council of 5 members, the power in the Act has been given only to the council and not a part of the council, unless the rules or the Act provide that only provision for quorum, that even though the council consists of 5 members, 3 will be considered to be appropriate quorum. There is no provision. On the last occasion, my lord had asked that question. Kindly see section 18. The power to decide the reference has been given to the council, not few of the members of the council. If I may place section 18, subsection 1, notwithstanding anything contained in any other law for the time being, enforce any party to the dispute with regard to any amount due under section 17 may make reference to council. Council has been defined in section 20 and 21, 3 to 4. In exercise of this power of 3 to 4, they have chosen 5 members. So the decision has to be by 5 members.
How do you get that?
My lord, may I just place the rules first before this? Huh?
This is too technical and absolutely doesn't make sense at all.
My lord, this is anyway on the merits, my lord, when my lord is considering section 36 too, my lord, whether I'm entitled to. Kindly bear with me for 2 minutes, my lord. My lord has already read section 21. It says that the council shall consist of not less than 3 but not more than 4. Kindly take the rules now, which we had filed on the last occasion. Where is the rule? We did not file this.
Today, what is the matter listed for?
Extension of interim order.
Extension of interim order, my lord.
And our GA for vacating of the interim order.
My lord, the interim order was till 5th of May 2025. 26, my lord, on that date, the election results were declared. My lord, the matter was fixed on 29th, 4 days prior, 29th of April, 4 days prior to the expiry of interim order. 29th was the last date for phase of election, so the matter could not be taken up. We mentioned the matter on 5th. My lord said we should make a formal application. We have made that formal application. My lord will kindly extend the interim order.
Lordship,
So you have made an application. He has made an application.
Yes,
for,
my lord, he has made.
so
They have made an application for dismissal of my application for interim order on the ground that the amount which I have deposited is not sufficient. My lord, may I?
That is not
back to
the only
original
point.
The award, if I may show it again, page at 34.
Presently, Lordship, my application need not be
Let me
heard.
hear her,
Lordship.
then I'll hear you. Am I going somewhere?
No, Lordship.
Why are you in a hurry?
The award, my lord. The respondent is at page 34, the ordered portion at the bottom, paragraph number 2. The respondent is directed to pay outstanding amount of 1,52,90,855.84 along with interest on each and every due amount payable as per section 16 of MSME Act 2006 till realization of the amount of the petitioner from. So what was quantified is only the principal amount and interest as per section 16. Section 16 says, my lord, I have to pay compound interest and 3 times the bank rate interest. I deposited 122 on the last occasion. My lord had asked on what basis did I deposit 1,22 lakhs. My submission is that 1,22 lakhs which I deposited is 25%, 75% of the principal amount and 75% of the interest from the date of the award till the date of filing of section 34.
Where do you get that?
My
That you
lord.
can deposit 75% of the interest amount. How do you calculate that?
My lord, I've given that calculation.
No, but this is your own calculation. This is not in terms of the act. You can't do your own calculation, madam. The calculation
My lord,
has to be
since
in
the-
terms of the act.
Yes, my lord.
And don't try to twist the terms of the act.
No, my lord, that is not my.
All right. So I'm not concerned with what your client does. But as far as the law is concerned, you have to deposit the money in terms of section 16, and 19.
Yes, my lord.
So I'm not concerned with your calculation at all.
My lord.
Your calculation has to be correct. Whichever method you evolve is not something which I'm going to look at.
My lord, since the award was silent, my lord.
Let him file his reply. Let him
My lord,
also file your reply. We'll see that.
My lord,
Because if this is the way you calculate, I'm not going by your calculation,
My lord, my
75%,
humble submission, my lord,
65%, 25%.
My
What
lord,
is this?
My lord will kindly consider, my lord.
If some Babu sitting in your organization decides to do his own calculations, we will not go by that.
My lord will kindly appreciate, my lord. It has not been the endeavor, my lord, to mislead or my lord to play with the requirement of the section, my lord. Since it did not quantify, my lord, and since what would be the due day is not.
Madam, do you have a CA in your company? You have an accountant?
Yes, my lord. We have, my lord.
Can you advise him?
We will make the calculation as per this.
Please do that. Then we'll see it.
My lord will kindly grant us liberty
Don't
to
take me
file.
here and there.
My lord will kindly grant us leave to file opposition to the application which they have filed because they have given a calculation over there.
File your opposition.
And my lord will also kindly record filing that I filed a supplementary affidavit today in terms of my lord's earlier order.
Supplementary affidavit doesn't help me at all, madam.
Since my lord had given leave,
Yes, I
my
will
lord,
take it on record, but
I'm
there's
so
nothing
grateful,
in
my lord.
supplementary affidavit filed by the petitioner is taken on record. Full stop. Your GA number is?
GA number?
GA1.
Ours is 2.
Yours is 2.
No, it doesn't matter.
Lordship, may I just make one submission, my lord?
Yes.
Which
GA2 is for my vacating of the interim order. My learned senior friend wants to use an opposition to it. I don't stand in that way. But my GS2 comes into force after GA1 is actually allowed. So once my lord hears out GA1, later on we exchange our pleadings.
File your reply to GA1.
Yes.
Let him file his reply to GA1. We'll
My lord, because they have given a calculation in their application, my lord.
You're not concerned with their calculation.
So, my lord, I'll file a calculation by my lord.
Do your own calculation. GA1.
My lord,
Application filed by the
may I make one?
GA1 is your application.
GA1 is my application for extension of interim order.
Which I'm opposing.
Yes, tell me what were you saying?
10 days, my lord, I'll file.
Sorry?
My lord is
No, I'm asking, you said something.
No, my lord, I did not. Sorry, my lord, I was talking to my junior.
Petitioner has preferred the present application seeking extension of the interim order of stay on execution proceedings pending before the district court at Belapur, Navi Mumbai.
Your G is in which application? In 34 is in 36.
You will start your execution proceedings if the stay is not granted to her.
It's already pending, my lord.
It's pending.
Yes, my lord.
I'll allow this application. I'll consider your application.
Lordship, may I then just make one and try to
Yes.
convince Lordship? Lordship, the 34 application can only be filed after the statutory mandate of section 19 is followed. My lord, may I just place this order once?
I know that.
Lordship. So, my learned senior friend's case is that natural justice at all has to be followed. Lordship, this order of your Lordship specifically states that natural justice is no point if the pre-deposit is not made prior to moving or filing of the 34. No, it cannot be entertained at all. If it cannot be entertained, Lordship, there is no question of any interim order. And if there is no interim order, Lordship, there is no question of any extension of the interim order. Lordship, the that 75% that which they are depositing, it should have been done prior to filing, not after the passing of the order. Lordship, if my lord may not extend it, I will keeps it for some occasion. Let me place this case. I will not
This is
proceed.
an application filed by the petitioner seeking extension of the interim order granted earlier by this court dated 15 September 2025. First off, learned counsel for the petitioner, learned senior counsel for the petitioner states that the interim order granted earlier has been extended from time to time, and the order And the last extension was granted on 10th of March 2026, wherein the interim order was extended for a period of 8 weeks. And the matter was listed on 29th April 2026. Full stop. It is contended by the learned senior counsel that the matter was not listed on 29th April 2026, that being the day designated for polling of the Legislative Assembly elections, as a result of which this court did not preside. Full stop. On 30th April 2026, the matter did not appear in the daily list, and due to resolution adopted by the bar, it could not be mentioned without the presence of both the parties. Full stop. On 4th May, the matter was listed as item number 68 of the monthly list. However, due to resolution adopted by the bar, no order could be passed by the Honorable Court without presence of both the sides. Again, the matter was listed on 5th May. The learned counsel for the petitioner mentioned the matter on 5th May 2026 for extension of the interim order, which was expiring on the same day. And this court had directed the petitioner to file an application for seeking extension of the extension of the interim order. It is noted that the petitioner had already procured the stay of the award passed by the Micro and Small Enterprise Facilitation Council, CONCUL. Award dated कर देना 20th September 2024. The petitioner had deposited 75% of the awarded amount in terms of section 19 of the Micro, Small and Medium Enterprise Development Act 2006. Full stop. Learned counsel for the respondent states that the amount deposited by the petitioner is less than 75% of the awarded amount. Full stop. He further states that an application has been preferred by him as GA2 for vacating the stay of the interim order. Full stop. Be that it may, since the petitioner has been enjoying the stay of the award dated 20th September 2025 since 15th September 2025, and for the reasons stated in the application and the arguments advanced by the learned counsel for the petitioner, this court is inclined to extend the interim order granted earlier for a period of 8 weeks from today. With the aforesaid observation, the present application is disposed of. Full stop. GA2 then.
May I make a
This is
suggestion?
an application filed by the respondent seeking dismissal of the present petition on the ground of non-compliance with the mandatory requirement under section 19 of the Micro, Small and Medium Enterprise Development Act 2006. Inter alia contending that the petitioner has failed to deposit 75% of the awarded amount in terms of section 19 of the said act. Full stop. The respondent further prays for vacating the interim order granted earlier in favor of the petitioner on the ground that the 75% of the awarded amount has not been paid by the petitioner. Full stop. Learned counsel appearing on behalf of the respondent submits that pursuant to the order passed by this court, the petitioner has deposited a sum of rupees 122,73331.50 with the Registrar General original site towards compliance with the requirement of under Section 19 of the MSMED Act 2006. Full stop. It is contended by the respondent that the said amount does not constitute the correct 75% of the awarded amount, and the petitioner was required to deposit. What is your calculation?
Their calculation is 4 crores 3 lakhs, madam.
An amount of rupees?
4 odd crores.
Give me the figure.
4
Page.
3 lakhs.
Page. In your application.
Their application.
4032403.
003.50.
Full stop. Learned counsel for the petitioner objects to the said calculation. She states that the petitioner has duly deposited the amount in terms of Section 19 of the MSMED Act 2006, and that the petitioner full stop. She seeks and is granted 3 weeks time to file affidavit in opposition to the present application. Reply to the same, if any, within 1 week thereafter.
Stay is involved.
Stay, I've already granted stay for it.
That is why.
Madam, may I just make a suggestion? If
on myself,
if my
1
learned
week.
if my
1
learned
week, 1
senior
week.
friend agrees to it, I will withdraw the GA2 if we can thrash out the 34. There's no point dragging out the matter. So if I can withdraw my GA2, my lord has granted it for 8 weeks.
If the amount, the calculation has not been done correctly, then 34 is not bond.
Yes, that's it.
All right. She has to do that. She has to deposit
Very well.
whatever money she has to pay.
Computation.
Then only I can hear the 30. That is the reason why I'm allowing.
Lordship. Very well. Very well.
You do that, I'll hear your 34.
Lordship. Lordship.
I'll do a CA calculation. And
You do a CA calculation.
And annex it in my opposition. And kindly make it 10 days, my lord.
1 week. 10
days, my
10
lord, just to the Saturday, Sunday.
2 weeks.
2 weeks, grateful.
All right. Reply 2 weeks.
1 week.
Rejoinder, if any, within 1 week thereafter. Affidavit in opposition, reply to the said affidavit within 1 week thereafter. List after 4 weeks. We'll keep it up
Kindly
to
give the date.
Since this will come up for hearing 4 weeks later,
Yes.
and the interim order, my lord, has extended only
8
for
weeks.
8 weeks.
I'm grateful. I did not hear, my lord.
8
I'm so
weeks.
sorry, my lord. I did not. So grateful, my lord.
How can I do that?
Grateful, my lord.
Grateful, Lordship.
Supplementary.
The passover item number 7, your lordship indicated at 12, my lord, taking up.
Item number 7, right?
Lordship. Now, this is my section 29A application, your lordship. My lord will find the last order.
7.
7.
You have any objection now?
No, my lord, I have no objection.
7. 7 number. My lord
Just
will
the last
find
order.
at page 100, your lordship. Now, the time expired on 18th of May. We have filed it on 15th of May.
Take down. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for publication of the award.
Brother.
This court, by order dated 7/1/2020, had appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 7/11/2021. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months till 31/8/2023. Subsequently, comma. This court, by orders dated 23/8/2023, 3/9/2024, and 25/11/2025, extended the mandate of the arbitral tribunal and 19 January 2026, extended the mandate of the arbitral tribunal by 1 year, 8 months, 2 months, and the last one was
Your Lordship, on
Last was my last
2 months
4
and
months.
4 months.
and 4. Learned counsel for the petition submits that the learned sole arbitrator had undergone a heart surgery and thus there has been a delay in publication of the award. Full stop. The same fact is not controverted by the learned counsel for the respondent. Full stop. He has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon perusal of the materials placed on record, submissions advanced by the learned counsel for the parties, this court is conscious of the fact that the learned sole arbitrator had undergone a heart surgery and thus there is a delay, but the same is not undue on or unwarranted or intentional on part of the learned sole arbitrator in conducting the proceedings. Full stop. The learned sole arbitrator is requested to publish the award within the extended time period, keeping in mind the interest of justice, keeping in mind the advanced stage of the arbitral proceedings, and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 2 months.
Not 4 months, at least 3 months, Your
3
Lordship.
months from today. उसके बाद डाल देना. The learned arbitrator is requested to make all
Great.
reasonable endeavors. इसको last paragraph कर दें. The learned arbitrator is requested to make all reasonable endeavors to publish the award within the extended time period with the aforesaid direction. The present petitions is disposed of.
Great.
I'll come back.
It really started on 23.
No, this is my application, my lord. This is an application taken out, my lord, for release of securities. My lord, I filed an application under section 34 challenging an award. My lord, I filed a separate application for stay of the award. My lord, in that application, my lord, I was directed to deposit certain cash securities as well as bank guarantee, my lord, to secure the award. My lord, subsequently, section 34 was allowed, my lord. The award was set aside. An appeal preferred, my lord, challenging that order was also, my lord, dismissed, my lord. So presently, there is no list pending. I applied before the learned registrar for release of the security. My lord, I was directed a formal order is necessary, my lord. For
What about SLP?
no SLP has
Who's on the other side?
No.
Who's on the other side?
My lord, I have served, my lord. Nobody is appearing. This is the affidavit service.
You're appearing for IOCL.
My lord.
Who's on the other side? Serve them again.
I've served the respondent himself, my lord, and he received the.
Take down. Affidavit of service taken on record. None appears on behalf of the respondent. Petition is directed to once again serve upon the respondent within a period of 2 weeks. List after 3 weeks.
Three weeks.
Yes, sir.
SLPS. Are you sure SLP is not?
My lord, I have made a specific averment in my application. There's no list pending. I have checked out with my client just before, my lord.
Come back
There's
out.
no SLP, my lord. Nothing has been served upon.
If they don't appear next time, we'll.
24.
Well, this is my application for modification of your lordship's order dated 11th March 2026 for extending the time to deposit the awarded amount by way of cash deposit. Well, on 11th March 2026, I undertook to deposit the amount within 4 weeks. As such, your lordship passed the order. But within 4 weeks, my lord, we could not.
Deposit.
No, my lord, the agreement draft is lying with me, my lord. We can deposit it tomorrow or any day. My lord, your lordship order is at page 26.
Take down. First, you move this application, then this application. The petitioner has filed the present application inter alia seeking extension of time for depositing a sum of rupees 3.50 crores by way of cash security with the registrar, original side of this court, and for condonation of delay occasion in complying with the order dated 11th March 2026. Full stop. By an order dated 11th March 2026, this court directed the petitioner to deposit a sum of rupees 3.50 crores with the registrar, original side of this court within a period of 4 weeks from the date of the said order. Full stop. Learned counsel appearing for the petitioner submits that despite taking steps to comply with the aforesaid direction, the petitioner could not deposit the said amount within the stipulated period on account of certain internal, administrative, and interdepartmental formalities. Full stop. It is further submitted that the relevant period coincided with the close of the financial year, which resulted in unavoidable delay in obtaining necessary approvals and processing the payment through the accounts department. It is submitted that the demand draft of the aforesaid amount has been prepared in favor of the Registrar General, original side of this court, on 28/4/2026. Full stop. The petitioner therefore has approached this court for seeking condonation of the delay and leave to deposit the said amount with the registrar traditional side of this court. First off. Learned counsel for the respondent states that he has no objection to the present application. Full stop. Having considered the submissions advanced and the advanced by the learned counsel for the petitioner and the explanation offered in the present application, this court is satisfied that delay was neither deliberate nor intentional nor willful, and that sufficient cause has been shown by the respondent. The other respondent or
Petitioner.
by the petitioner has been shown by the petitioner for her inability to comply with the order dated 11th of March 2026 within the prescribed period. Full stop. In the facts and circumstances of the case, and in order to advance the cause of justice, the delay in depositing the said cash security is condoned, and the time for compliance of the order dated 11/3/2026 stands extended further by period of
Well, within this week I can find.
within a further for a period of 1 week. Full stop. The registrar original side is directed to accept the demand draft for a sum of rupees 3.50 crore, provided the same is deposited within 1 week from date. Full stop. With the aforesaid direction, the present application stands disposed of.
I'm grateful.
AP going on AP we'll see the AP will be in the list.
Item 283 of Monday list is the another matter. We have challenged the award.
283 is there in the
See,
list.
that is the AP, the main petition, right? To be hard together. This matter was. This is just an application.
$25.
25, Your Lordship. This is my application under Section 34 for setting aside of an award dated 17th of August 2025. Lordship,
Then I beg to appear on behalf of the judge or award determinant.
Your Lordship, I would presume that Mr. Shahu would want to use an affidavit, but just before that, Your Lordship,
Before
there is
that,
a-
Lord, I have only one objection. My Lord, may I indicate this? This is for the benefit of the petitioner as well. That they say in paragraph 41, page 32, that the award was received by them on 21st of January 2026. That there is no document or anything else to show that they had actually received it on 21st January. That what had happened is, Millard, there was a lien marked on the award because payments were due. Hence, Millard, we received an award on the separate date and they might have received. So there is nothing on record to show that they had received on 21st January. But that is my only objection because there's a question of limitation. Other than that, Millard, I'll only pray for affidavits. Millard.
Your Lordship, in fact, at paragraph number 41, I have enumerated that I have received it on 21st of January 2026. Of course, that is on affidavit. Should Your Lordship so direct, I can come back with instructions with respect to what documentary evidence there is to showcase the same. Even otherwise, Your Lordship, with respect to the date of receipt, we are beyond the period of 3 months, but within the extended period of 30 days, I've proffered my reasons as to the cause of delay.
Come back on Friday. Can't hear you, bro. Not today, Friday.
We'll do that. I'm grateful.
$26.
No, this is my Section 34 application. My Lord, the award was passed by my Lord, a three-member tribunal, Honorable Justice my Lord J.D. Kapoor, my Lord, Honorable Delhi High Court. Thereafter, my Lord, and there was a majority award and a dissenting award. My Lord, counterclaim allowed to the tune of my Lord 23.5 crores with interest around 30 crores. Where my Lord, the documents disclosed in the counterclaim for loss of profit were my Lord, petty bills like my Lord, computer charges, tire, and my Lord, there are no documents disclosed to my Lord substantiate my Lord, the counterclaim of my Lord 30 crores. Nothing at all. If we add those petty bills also, it comes to around 3 crores. all the petty bills that they have annexed.
Who's on the other side? Where's the affidavit?
My lord, I have, my lord, served. My lord, this is, my lord, the tracking report, because, my lord, initially I have to file with the affidavit of service, and this is, my lord, the tracking report, my lord, which shows that they have received it. If your lordship, my lord, permits me, my lord, I can serve and again, my lord, come back before your lordship.
Serve them. Learned counsel for the petition seeks and is granted liberty to serve upon the respondents since the service is not complete.
But service has been completed, my lord. This shows, my lord,
There's a tracking
initially, my lord, it was not done because
Where's
when
the
it was
tracking
filed,
report with your affidavit?
I had just handed it over.
It's just you're handing it over. It's not
I'll
with
file
your-
a affidavit of service. I'll do that.
Not complete. Let this 6 and 2 weeks time. List after 3 weeks.
No, your lordship has kept it after 2 weeks.
After 3 weeks. You'll
After
serve
3,
them
but I'll come back within a week. my lord.
within a week.
Within a week.
Then
I'll come back within
within a week.
Within a week.
Keep it after 10 days.
I'm so grateful to your lordship.
Keep it after 10 days.
I'm sorry, my lord.
After 10 days.
After 10 days. Great. I'll have to come back with a 36 as well. And 36 too, my lord, for my lord, the for perpetrated.
With the deposit.
Yes. No, my lord, not with the deposit. Grateful.
Monthly list. Item number 10.
My lord, I beg to appear virtually, my lord. I am for the petitioner.
Yes.
My lord, this is regarding an appointment of arbitrator. There were talks of settlement going on, which has miserably failed. And that's why, my lord, I am praying for your lordship's kind direction to appoint an arbitrator, my lord.
Who's on the other side, madam? Where's the service?
My lord, the other side had appeared on all the other occasions, but on Monday and today they are not appearing, my lord.
So let them appear. Serve them a notice. Where's the affidavit of service?
My lord, affidavit of service was served long back because it was filed in 2025, my lord.
All right. So inform them. We'll have it on Friday.
I'm grateful, my lord.
Item number 12.
Lord, I appear for the respondent number 3. Well, this is that matter, lordship, where there's an arbitration clause which says that disputes above 2 crore
Yes.
will not be subject to arbitration. Well, lordship had wanted to know from us what the position of law is with respect to such clauses. But we've come ready, my lord. After my learned friend finishes, we'll assist your lordship.
Yes. My lord, I have, for the sake of convenience, I have prepared a convenience compilation and a short note because there are a lot of documents. The relevant portions I have covered in my convenience compilation. Another একটা copy দাও।
Correct a copy.
হ্যাঁ, sure.
আরেকটা কপি ওনাদের আরেকটা
The grievance of my lauded counsel is this, that above rupees 2 crore, as per correction slip number 3, there will be no arbitration. This is very fair, no issue. But the question which comes for your lordship's consideration, whether correction slip number 3 is part of the contract or not. Now, lordship, I would request lordships to come at page convenience compilation. One moment. Lordship kindly comes to page 11 of my compilation.
Yes.
Lordship, in clause 2, what are the documents which will form the contract? Lordship kindly comes to the general conditions of the contract. The last dotted entry,
General
It says read with correction slip number 1 and 2. That's all. Nothing more, nothing less. Now, whether by virtue of another provision, whether it can be impliedly covered. Now, that provision is there at page 4.2 টা কোথায় আছে? হ্যাঁ? 4.2 টা?
Yes, can you quickly just give me a bird's eye view? I remember
Yes, Lordship.
distinctly that
Yes. Now, my view is simple that it has to be signed. That is the provision of the implied condition. But unless the bidder signs correction slip number 3, it is not forming a part of the contract. That is what I have covered in my note. And in this regard, Lordship, I have also.
no, what exactly is just give me the background.
My lord,
Just give me the background.
my lord, I believe because they are right,
For the respondent.
so he has to satisfy.
My lord, what has happened over here, main crux of the matter is this correction slip number 3, whether it is part of the contract or not. But my learned friend's only contention is that it has not been signed, not been referred to in the main contract, so it is not a part. My lord, my affidavit in opposition, my lord, I had indicated on the last occasion.
Now, let's not get into the merit of the matter. Just wanted to understand what exactly it is. The
Now, my
dispute
lord,
is pertaining to what?
Arbitration. Applicability of arbitration will
Yes.
only happen if the disputes are within 2 crores. That is as per the correction slip number 3. And if this correction slip 3 goes, then their claims are maintainable. So if I'm saying that this correction slip is applicable, then they cannot maintain arbitration. That is the bottom line of it.
Lordship, kindly comes to page 66 of my compilation. Last page. Lordship, the last line.
Yes, sir.
The successful bidder will be required to sign the complete tender document, part 1, part 2, part 3, and correction slips, if any, there are 2. Admittedly, correction slip number 3 has not been signed by the bidder. 1 and 2 signed, that is forming part of the contract. আমাদের ইয়েটা দাও না না আমরা যে রিপ্লাইটা দিলাম এয়ারটা কন্ট্রাক্ট আছে কোথায় আছে ক্লোজ
So all the correction slips, according to you, have been signed.
only 1 and 2.
1 and 2 have been.
Lordship.
3 has not been signed.
3 has not been signed. And their case is, as per correction slip number 3, the arbitration beyond rupees 2 crore of claim is prohibited. That is a simple point. That's all I have covered everything in my written notes of argument. And Lordship, I have also relied on a decision.
No, just before we get into the decision, what is the document which you are showing that the correction slip number 3 has been signed?
Has not been signed. Yes.
They are saying it has not been signed. You are saying it's been signed, right?
It has not been signed.
Not been
so that will appear from the contract document itself. Signed contract documents I have disclosed. It is there in the record.
Slip number 3 has not been.
What is saying, madam? Either you say,
Lord will allow.
No, I apologize. I think there is some error. My senior is trying to say that the correction slip number 3 was not signed by the parties.
My lord will allow
Not
me.
signed, yes.
Not
If your lordship permits, I'll explain in 2 minutes. But what has happened is my learned friend is referring to the entire tender documents. He is saying the contract, which is of 2 pages, it refers to certain documents which says these are the documents which will fall in hierarchy and will be binding on all the parties. There, correction slip 1 is mentioned, correction slip 2 is mentioned, correction slip 3 is not mentioned. Correction slip 3, my case is that is an omission in the contract document itself. Correction slip 3 is very much applicable. Why I'm saying it's applicable? My lord, I had indicated that all the documents from the day 1, including the tender documents, were all uploaded. They have received the tender documents online. They have given their bid online. They have applied online. Correction slips 1 and 2 have been given online. They have received from there. That is what is mentioned in the contract also. Correction slip 3 has been uploaded in September 2020 and contract has been finally executed in March 2021. So, my lord, they are trying to take advantage of one omission that in the contract documents, correction slip 3 word is not mentioned. Now, my lord, my learned friends should also explain to your lordship, my lord, kindly takes my learned friend's application and kindly takes page 51 of the application, my lord. This is the notice of the dispute.
What application?
My lord, the main application, section
11 application.
Yes.
page 51 if your lordship has.
Yes.
My lord, this is the form in which the dispute has to be referred. My lord, kindly take the right hand side portion. It mentions annexure F2. Your lordship has it?
Page 51, right?
Yes, my lord.
Annexure F2.
Annexure F2. My lord, just below that, refer clause 25.4.
Yes.
Your lordship will kindly note this 25.4. Now, my lord, kindly takes the affidavit in opposition of the respondent number 3, page 271. That is, my lord, the original clause 25.
I get your point. Let him make his submission.
Very good.
Lordship, I have filed the affidavit in reply.
Yes.
Which
So
is
first
what-
is your convenience compilation. What are the documents which you're trying to show from there? Anything in
in
particular?
my compilation.
Yes.
Huh?
Since you're filing it today only, right?
Yes, today only.
So
We are
tell me what
filing, but the
all do you
entire
want me to
contract
see?
document we have filed, which is in the volume 3. Lordship kindly comes to Kotagal volume 3, last page.
I just want to understand your compilation, the convenience compilation. What all documents you want me to see from here?
Yes, the compilation documents in my notes, Lordship will find that only 3, I am relying only on 3 part. One is that contract document which I have shown. Then another is at page,
Contract document which you showed me on page.
which is at page.
It starts at page 9. The contract document starts at page 9 of the convenient compilation.
Is the agreement, right?
Yes, Lordship. And the relevant page is page 11, where the document which forms part of the contract have been mentioned.
General conditions of contract, right?
Lordship. General conditions of contract read with corrections
Read
with
with
no
correction.
1 and 2. It does not mention about
3.
3. Now, Lordship, on my compilation, Lordship kindly comes to the last page, page 66. It says general conditions of the contract, compilation so and so. The last line, the successful bidder will be required to sign the complete tender document, part 1, part 2, part 3, and correction slip, if any. So the correction slip 3 was never signed. And it is also not part of the contract document, which was also executed between the parties after this contract was awarded to us. So therefore, if a document which has not been signed only impliedly, whether that can be considered to be part of the contract or not, my lord, kindly consider that. That is my only case. And I have also relied on a decision, but that is not very important. Thing is this, when the express provisions of the contract are before us, Lordship, therefore, whether we should go for a implied provision or not. Their case is, it should deem to have been presumptive condition. It will be presumed that you have seen everything and done. But it is actually not the case. Intention of the parties was not to include correction slip number 3, because correction slip number 3 was came into force even before the contract was awarded. So they have intentionally avoided to include correction slip number 3.
Anything else?
90 bar code.
Yes.
I may be allowed, Lordship. As the other side has already mentioned that the claim that was submitted was as per the form F2. And they have mentioned that the F2 was there in the correction slip number 3. So it is deemed that we were already aware of the existence of correction slip number 3. But Lordship, if you come to page 40 of the convenience compilation,
yes,
it's clause number 31. Lordship, in page 13, the third line, it mentions it is a term of this contract that party invoking arbitration shall give a list of disputes with amount claimed in respect of each such
Just a
dispute
minute, just
along with the notice.
a minute. Where are you reading?
Lordship, page number 40, the
40?
first page, first line.
It is in terms of the contract that
Yes,
part.
Lordship.
Yes.
In terms of this contract, that the party invoking arbitration shall give a list of disputes with amount claimed in respect of each such dispute, along with the notice for appointment of the arbitrator in form at annexure F2. And Lordship, if you come to page 42 of the same convenience compilation, the annexure F2 has already been mentioned, which is a signed document as can be seen at the end of the page, which is a part of the tender document and contract that has been signed by the petitioner. The fact that the claim notice has been served in accordance with annexure F2 has nothing to do with us, with the petitioner being aware of the correction slip number 3.
Anything else?
It is Lordship, page 42. The contention is that since we have submitted our claim as per annexure F2, which is part of correction slip number 3, it will automatically.
She has explained that.
Okay, you please explain.
No, she explained it.
She explained it. Yeah, I am deeply obliged, Lordship. They should also come up because she has read the case more than me. So, Lordship, if F2 is part of the original contract, then my placing the claim as per F2 stands. So it is also a part of correction slip number 3. It does not mean that it is not part of the contract. So these are 3 points, Lordship. I just, at the cost of earning displeasure, even Lordship, I just say that correction slip number 3 or any correction slip, unless it is signed as per the provision, it is not part of the contract. Number 2, that it is an implied condition that all correction slips will be deemed to have been considered by the bidder. It is not the case because of that, because it overrides this clause. And the third point is the claim that we have referred to arbitration is as per annexure F2, which is part of the contract document original. It is also a part of correction slip number 3, but it does not mean that it is not there in the correction slip number F2. These are the only 3 points, Lordship. Rest of the things will decide.
And Lordship, the bid document disclosed by them does not bear the signature of either of the parties, whereas the bid document that has been disclosed by us
are signed copies. Yes.
Signed copies.
Right.
Judgments, what are you relying upon?
The judgment is mentioned of the Navaprabha, the short notes that was handed over to you, Lordship. It is at the.
Which paragraphs of the judgment?
Yes, Lordship. Now read it.
Yes,
Lordship,
tell me.
I just.
Let her assist.
Yes.
Yes, tell me. What is it?
Wait, please do it.
The junior should get some opportunity. With
Lordship,
the help of the senior.
Yes. Let her do it.
much obliged, Lordship. Lordship, the head note itself in the page number 7, mentions that the terms harmonious construction of contract as a whole, then it mentions terms may be implied by court. Then it comes.
Yes.
We will come to the paragraph.
Lordship, she will explain on the same head note held in deep held if the terms are explicit in their expression. The explicit terms of contract are always the final word. With regard to the intention of the parties, and multi-clause contract has to be understood and interpreted in a manner that any view on a particular clause of the contract should not be violence to another part of the contract. When here my case is, when the terms are expressly provided, then any other terms which can be implied into the contract, which will be in violation of the original contract, that is not permissible. That is what has been mentioned here. So it's all.
But this could be looked into by the arbitrator also.
Yes. Yes.
My lord, what my learned
He'll hear
friend
you
has-
after lunch.
My lord, may I just indicate?
He'll hear you after lunch.
Okay.
Anything else? This is the only
No,
judgment?
That's yeah.
Any other judgment on which you're relying?
No other judgment. If they want to show any other judgment, then I may take the liberty.
After lunch video.
After.
Yes, Ms. Pandey, to mention.
Funding matter at not 12.
Lord, kindly takes my lord the convenience compilation ones what my learned friends have filed today
Yes.
and takes my lord page 31 straight away. Or at the cost of repetition, my lord, 29 onwards. 29 is that notice by which they have referred the disputes. My lord has page 29, my lord. My lord, I'm referring to the first thing that is written on the letter, annexure F2, refer clause 25.4. Lord, this is 25.4 is something which is of pertinence, my lord. My lord, kindly takes now page number 31.
Yes.
Now, my lord, this clause 25 appearing at page number 31 is, my lord, part of the original contract.
Yes.
Now, my lord, I won't trouble your lordship. Kindly takes page 39 straight away. 40, my lord, page 40 straight away. So this clause number 25 is running up to page number 40. If my learned friends had invoked, my lord, this particular clause, then the notice would have mentioned clause 25, subclause 32. This is paragraph number 32. The number is not visible, my lord. Page 39, your lordship sees it's paragraph 31 which is mentioned. Page 39, last paragraph is page clause number 31. This is clause number 32. And my lord, this refers to form F2. So what they have done is they've issued a letter in annexure F2 format. But my lord, they have issued under the clause which is forming part of correction slip number 3. Now I'll show, my lord, correction slip number 3. 25.4 of correction slip number 3, my lord. That is at page 46, my lord, of the same compilation. Yes, my lord. Correction slip 3, my lord, has first thing is mentioned clause 25, your lordship has it. And my lord straight away takes page number 49, clause number 4. Same clause, referring to form number F2.
Where are you reading?
My lord, page number 49 of the compilation.
No, 49, yes.
49, clause 4, in the middle of the page, my lord.
Yes.
This is, my lord, my case in long and short. My lord, the notice which they have issued, my lord, is under clause 25.4. Clause 25.4 features in correction slip number 3 and not in the original contract. Had they issued form number F2 as per the original contract, it would have shown clause number 25.32 and not clause 25.4. Now, my lord, I've already indicated on the last occasion, my lord, this compilation does not contain, my lord, one annexure, which is part of my affidavit in opposition. My affidavit in opposition, page number 14, if my lord could take. Affidavit in opposition of respondent number 1.
Yes.
My lord, page number 14, if your lordship takes. My lord, this is, my lord, a screenshot to demonstrate when the tender documents and the correction slips were uploaded. This is the website of rights, my lord, my website. My lord sees general terms of the contract 2019, correction slip 2019, correction slip 2 2020, correction slip 3 September 2020, correction slip 4 October 2020. Contract has been entered into in March 2021, undisputed.
So correction slip number 4 also they have signed it.
My lord, correction slip 4, this question fell from your lordship. My lord, your lordship put this question to the petitioners, my lord, on the last occasion. My lord, that, my lord, petitioners have not answered.
You have signed it.
Correction slip number 4 have been signed.
That is
No.
one question.
You have signed?
No. Correction slip number 4 has never come into the picture.
And my lord, again,
But
take
this correction slip number 3 for the first time, they have mentioned in their response to my invocation to arbitration. Before that, it was never in the picture.
No, it was there.
No, I'm asking, see, these are all part of the, first is the GCC, then the correction slip number 1, 2, 3 and 4.
3 and 4 is not part of the contract.
Not part of the contract.
No,
You have
Lordship.
not signed.
No, Lordship.
My lord, my case is that all the documents were uploaded online, bids were submitted online. From there only they have downloaded it. And my lord, last page of the compilation, page number 66.
So
Your
when
lordship
was it signed? The final bid was
21st March 2021 is the date of the contract.
21st March 2021. All
And July 2020, I'll get the date, my lord, is the date of the bid when they have given 2020.
So when they had given the bid, the correction slip number 4, 3 and 4 were not there.
Correction slip number 3 and 4 were
Correct.
not there.
Not there.
Yes. Correction slip 3 and 4 were not there. But my lord, these correction slips were uploaded. Term of the contract itself says that it will be deemed to be binding upon the contractor. My lord, that clause is also, my lord, appearing at page 66 of the compilation. My lord, kindly takes page 66, clause number 4.3. This is one of the second last page of the compilation. My learned friends placed this clause, but my lord, this portion, my lord, needs little emphasis. My lord, last 4 lines. It shall. 5th line from the bottom, my lord. It shall be presumed. Your lordship has it?
Yes.
Yes, my lord. It shall be presumed that the bidder has read the contents of part 1 technical bid, part 3 general condition up to correction slips thereto, and the same will be binding upon him.
Yes.
And my lord, today there is no statement from them justifying why the notice of dispute mentions clause 25.4. There is no such clause 25.4 in the original contract, my lord, which demonstrates, my lord, giving a form F2. Now the F2 25.4 is in correction slip number 3 alone. So the judgment which they have referred to is, my lord, on interpretation of the contract, how the court is going to interpret the contract. My lord, here the party has himself understood what the term of the contract is. He has understood what correction slip 3 is, issued a notice in terms of correction slip 3, which is demonstrated from the notice itself, which mentions clause 25.4. This is, my lord, my case.
Where's the notice?
My lord, page 29 of the same compilation. Here the courts, my lord, will not have to interpret for, my lord, my learned friend. My learned friend's client has himself interpreted the contract. And in right earnest, today they have come to take advantage of an omission in the contract. Page 29, refer clause 25.4.
But even 25.4, clause 25 starts from
page 31
page
of the
31.
compilation.
Page 34 is clause 5.
Lordship kindly looks at page
Just a minute.
42.
Yes, sir. If any party is dissatisfied with the decision given by the appointing authority, so and so, it shall ask for the appointment of the arbitrator.
My lord, form F2 is what they have issued. That is what is to be issued. Well, original contract, yes.
When you are reading 25.4,
yes, sir,
and saying that it is only fine mention in slip 3, Correction slip number 3.
25. Yes, my lord. I understand.
25-4 is also
There in the contract.
it's here also, right?
My lord, your lordship is reading correction slip number 3 only. Your lordship is holding correction slip 3. No, my lord. I'm sorry, my lord. I'm sorry. Correction slip 3 is page 46. Page 46. I'm sorry, my lord. And correction slip 3, the clause is at page 49. 49 has to be read, my lord, with page number 39. Page 40. Page 40 and 49. Your lordship reads them together. Form F2 কথা তো এখানেই আছে।
All right.
দেখুন না 32 তো দেখাচ্ছি 32 ঠিক আছে কম্পাইলেশন দিয়েছেন উনি তো কম্পাইলেশন থেকে আমি দেখিয়েছি আগের পাতা দেখিয়ে দিয়েছি আগের পাতার মধ্যে পেজ 30 প্যারা 31 দেখাচ্ছে না আমি আগের পাতা দেখালাম
Yes.
Put it simply, my lord, had they only mentioned form F2 and not the clauses, my lord, then it would have been a different case. Here, my lord, they have particularly mentioned clause 25(4) and that corresponds to correction slip 3 alone. That is my case.
Lordship, just 30 seconds. Kindly comes to Lordship, page 42 of my compilation. That is the format of F2. It was refer clause 25(4). That was original part of the contract. So therefore, my reference was in terms of 25(4) as per annexure F2.
You are checking the original contract.
This is your annexure.
My lord,
F2 is your annexure.
Lord,
They have not added anything. Your
F2,
if I understand correctly, your argument is that since they have issued it under F2 and they have specifically put 25(4), that would mean that they are relying upon correction slip number 3. To that, their counter argument is that this F2 form, they have not added anything nor subtracted anything. F2 form itself refers to clause 25(4).
Lord, I'll check the tender documents.
Your original tender document F2 form itself refers to clause 25(4). They have not incorporated or interpolated or have added this 25(4) on their own.
Lord,
So that understanding of yours that it is because it finds mention in correction slip number 3, so they are well aware and they have added this is not correct. It's not.
My lord, to that, my lord,
Show me from the tender document.
yes, my lord. Let me just check, my lord, the tender documents once. My lord, as far as my understanding is this form, subject to what my learned.
No, it's an innovative argument, but if it is contrary to record.
My lord, it is, my lord, I'll have to check, my lord. Again, I'm saying this 25(4) can come
Today
only
they are showing it from record. They are saying that this is not a notice which they have
Page number.
created. The notice itself says F2 and 25(4).
Yes, my lord.
They have not added anything. According to you, they have understood this and they have added and they have incorporated 25(4) in the F2 notice.
Yes, my lord. That is my case.
That's not that case
That
is
is
not
my
correct because if the tender document doesn't show that, then the
Original
understanding is right. Their understanding is right.
My lord, I'll have to check the original tender document. My lord, page number 377 টা দেখুন, I think it is part of the affidavit in opposition.
It is there, volume 3. I have discussed the entire contract
377 is the form.
of the affidavit.
Number 3.
Yes,
আপনার
page
affidavit in
377.
reply টা খুলুন tender document. Opposition ने reply তে উনি document লাগিয়েছেন পুরো tender document. Okay. Their reply to their opposition. My reply does not contain. My opposition was only on this point. And it is a thin reply. I'm asking from them.
No, your argument is faulty if that is the case.
Yes, my lord. If that is the case, then my lord. We will not get it because they have not. এটা 377. My lord will then kindly keeps this matter there. My lord, any other day, I'll take instructions and I'll come back.
Heard. Learned counsel.
Will kindly give us some time. We have a point of jurisdiction as well in terms of that clause. When Lordship takes it up on the next occasion, we'll try and.
My lord, learned friends for respondent number 3.
My lord, the respondent numbers 1 and 2.
Make your point.
Lordship, then I'll place it right now. But I would only add to it by showing page 56 of the compilation
Compilation filed by them.
by the petitioner lordship.
Page
56 of the compilation.
Yes. That's the general obligation.
Lordship will see court jurisdiction. Otherwise, unless specified in Schedule F, courts in Delhi, India shall have the exclusive jurisdiction to entertain any suit, application, or other proceedings in respect of anything arising under this contract or any award or awards made by the arbitrator where Arbitration Act is applicable shall be filed in the concerned courts in Delhi only. Now, there's also a clause which says the place of arbitration will be Delhi. So, if Lordship, after hearing my learned friend, because after all, he's the one who conducted the process, but if on the next occasion Lordship comes to the finding that this correction slip number 3 was indeed part of the contract, then in any case, the petitioner cannot maintain this before your Lordship.
What do you have to
The
say? on-
jurisdictional point has come only in correction slip number 3. Kindly comes to page 46, and this is the last page 56.
Well, I made that submission.
So
That
again,
if Lordship
same
comes
situation.
after considering my learned friend
Well,
on the next day, then
this is only all this is done subsequently. Nothing else. All this
Lordship
is
will have just
addition, subsequent additions. Heard. So and so, so and so. Keep it for further hearing on. Give a date. When do you want?
Lordship any date.
How much time will you take for
Monday? Monday want to hear.
next week? Next week.
This
Keep it
Monday.
next week so that I still remember it. Otherwise, it's very difficult.
Yes.
Grateful.
Monday. Let's keep it Monday. We'll finish it off on Monday.
Grateful.
Monthly stagnant on 13. Monthly stagnant on 13.
Tamila Mohila Samiti. Dismiss for default.
Hmm.
14. Monthly static number 14.
Spam for the petitioner. This is my application for appointment of arbitrator, Lordship. Service is complete, Lordship.
Service is complete.
Service is complete.
Where's the arbitration clause?
Lordship, the respondent number 1 is construction company.
Yes.
They are involved in the construction of roads, bridges, flyovers, stated in paragraph number 2, Lordship. Accordingly, they was awarded with a tender for construction of upgradation for Kalyani Expressway 4 to 6 lane, and for that they were required a plot of land for setting up a hot mix plant, wet mix plant, and they approached the petitioner for a land about 7.682 bighas, and accordingly an agreement was executed between the parties on 1st July 2024. Agreement is at page, Your Lordship, page number 13, and the arbitration clause is at page number 1725, clause number 25, page number 17. A dispute arose between the parties with regard to lease rent. The petitioner sent a demand notice that such and such amount is due, and without expiring the even after the expiry of the agreement, they kept the possession under themselves and did not pay the lease rent amount. Accordingly, the several replies were received, and ultimately the petitioner sent a letter dated 1st November 2025.
Where's the clause? Arbitration clause.
Arbitration clause is at page 17, Lordship, clause 25.
Yes.
Yes, Lordship. Lastly, the petitioner sent a letter dated 1st November 2025 for under section 21, for invoking the provisions of arbitration. It is at page 30, Lordship, annexure F. And in response to that said letter, 1st November 2025, the respondent had responded on 25th November 2025. Last para is at page 36. The respondent, they have responded like, further, our client is always ready and willing to sit with you for amicable resolution of dispute if you are ready and willing to provide the back goods.
This is not a section 21 notice, sir.
20 on page 30, Lordship.
It's not a section 21.
It is not, there is no mention of section 21.
So you want me to dismiss it on this ground, or you want to withdraw and issue a fresh section 21?
Lordship, kindly grant me 1 minute. Lordship, there is no mention of section 21, but approach.
I will not go on the approach.
Approach is just
Whatever.
like section 21.
Very good. Excellent. You want to withdraw, or you want to issue a fresh section 21 notice to them?
Lordship, kindly grant me liberty and I will come again.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
Lordship, one more indulgence, Lordship.
Yes.
Kindly observe that section 21. But for
I will observe, then I'll dismiss it. If you want me to dismiss the petition, I'll dismiss it. No problem.
pardon, Lordship. Kindly grant me liberty.
You have not issued a 21 notice, sir. We don't assume things.
Much obliged.
15. So 16. 16.
And for the respondent, my lord, Lordship, I am for the petitioner. We filed a reply. I've taken leave to file a supplementary affidavit because they had denied my section 21. In my reply, I have placed the by which I have served the section 21. And I have also in the supplementary filed my section 63 affidavit stating that the same was served upon them. In their opposition, they have taken 2 points. One is of limitation. Their opposition, page 5.
Where's the supplementary you filed?
Your Lordship, I filed it right now. I've served my learned. The section 21 notice is at page 230, Your Lordship.
Page number?
230 of the main petition, volume 2, Your Lordship. Annexure G.
You have served the section 21 notice to Hammurabi Solomon. That's a law firm.
Through her, that's a law firm. It has served to the Banjan Hard Coke Private Limited, page 230, Your Lordship, and it was served through their a legal notice was sent, section 21.
Who's the respondent here?
The Banjan Hard Coke Private Limited, page 230 is my section 21 in the main petition, Your Lordship.
230.
230.
Second volume though.
Volume 2.
How did you serve them?
I served them through email, which I have annexed in the affidavit in reply at page 17, Your Lordship. The law firm had served them through email. Even my section 11 was served through email, which they have served, which they have received, and they appeared.
Yes.
I have instructions, my lord, that they have not received the section 21 notice. If my lord comes to their annexure B to the reply that they have filed at page 17, my lord, the email itself shows there was no attachment.
Page 17.
Yes, my lord. My lord, page 17 and 18 are the email.
Where's the attachment?
Also, my lord,
Pandey,
Your
there's no
Lordship.
attachment. You forgot to send the attachment.
my lord, the email also talks about a physical service of the notice. However, my lord, no proof of service has been provided.
Even if there is no attachment, Your Lordship, the subject matter is section 21.
Sorry, that will not do.
Your Lordship, I'll take instructions and I'll produce the computer by which whether the attachment was there or not. Kindly allows me 1 day's
If it is not
accommodation.
there, then you have to send
Your
them in.
Lordship, I will take instructions whether the attachment was there or not.
And even you're talking about a hard copy being sent out. Even that has not been
To the
done.
best of my knowledge, the hard copy was not sent, but the email was sent. That instructions I have.
Without attachment, it
Your
will.
Lordship, I'll just check on the attachment.
Supplementary affidavit is taken on record. Learned counsel for the respondent. You have filed a reply to the supplementary affidavit.
No, my lord, I've just received the copy now.
Learned counsel for the respondent seeks and is granted liberty to file reply to the supplementary affidavit, since the respondent alleged that the supplementary affidavit showing proof of email service on the respondent itself shows that the notice, that the email has been sent out without the attachment, and thus the section 21 notice was never served upon the respondents. Full stop. There's no point filing a reply. I'll record your contention. This is your contention, right?
Yes, my lord.
Reply छोड़ दो. Learned counsel for the respondent ऐसे कर देना उसको. Reply छोड़ के कर दो. Learned counsel for the respondent has raised an objection. वो रहने दो. क्या लिखवाया है एक बार बताना फिर से. वो छोड़ दो. हाँ. Section 21 notice. Section 20 served upon the respondent. Full stop. Learned counsel for the petitioner seeks time to take instruction if the mail was sent out without an attachment of the section 21 notice list. When do you want? Next week?
Monday, Your Lordship.
Monday. List on Monday. If that is the case, Ms. Pandey, send out a new notice. Finish it off.
Your Lordship.
You're in time or you're...
Your
There's a
Lordship, when I send the notice, I was within time.
My lord, even that
31st December 2025, I was within time. Because I'm covered by the COVID judgment.
My lord, that judgment, they're not covered by that judgment. I have my submissions for that as well.
Yes.
Grateful, my lord.
Obliged, Your Lordship.
Monthly statement was 17.
17 money appeared for the respondents.
Who's for the petitioner? 20. You're not there?
Your Lordship, we are for the respondents.
Damodar Valley. Sometimes you're for
No, Your Lordship, Railway.
Railway.
petitioner is Damodar Valley, huh? Or who's the petitioner? 17.
Damodar Valley,
17 is what?
17 is Railway.
East
Railway. Bakshi.
Bakshi and
Bakshi and
Eastern Railway.
Where's the 21 notice?
There is no.
Well, there is, as it appears, well, there is no section 21 notice.
Dismiss for default. Dismiss for default. None appears for the petitioner. They have not put the 21 notice.
As I have checked up, my lord,
We have made a advertisement, but not
statement, but not annexed.
None for the petitioner. Respond.
Monthly side number 33.
Yeah, hey, look, why they're not coming?
Monthly side number 33. Become 364 of 2026.
Dismiss for default.
And now 35.
Receive application, huh?
Same.
No application. Dismiss for default. Both the applications. GA1, GA2. Dismissed. Dismiss separate order.
37. Monthly side number 37.
Yes.
Lordship, the sale did not go through. The buyer backed out.
Buyer backed out. Then she'll again.
I'm the receiver minded in this matter.
She'll again try to sell it off.
Lordship, as per my instruction, they will have to conduct the auction.
Yes, that's what. Carry out the fresh auction.
My lord, according to the petitioner, I came to know that Since the fact, my lord.
I'm
But
sorry?
They will take, they are taking the option, my lord. Again, they will option.
Oh, no, action will be carried out by you.
Yes, my lord.
Yes.
But today I came to know that they.
The buyer has backed out.
First buyer, my lord.
All right.
Backed out.
All right. Then you carry out the auction. Learned counsel. Learned counsel for the petitioner states that the bidder did not come forward and that the earlier round of the bidding process has been vitiated due to the same. Full stop. The receiver is directed to initiate fresh auction for the sale of the machinery. Full stop. Let a report be filed by the receiver on the next date. List after 2 months. That will go in 3rd of August. 3rd of August. Try to do the process. Yes, 39.
38.
38.
Your Lordship, in the previous occasion, there was a direction to submit the reports, Your Lordship. It would be
You have given a copy.
Yes, Your Lordship. I've already
Yes,
serviced.
what is there in the report? What is there in the report?
Your Lordship, in the main report, Your Lordship kindly peruse to page number 42 in the main report, Your Lordship.
Yes.
Your Lordship, there is this order that I have received from Manish Dasgupta. He is the GST officer. Your Lordship, the equipment is confiscated from the GST department due to some e-way bill payment issues. So for that reason, he showed me this order sheet that is in circuit bench at Jalpaiguri. There is an litigation that is going on. And Your Lordship, kindly peruse to page number 43. I have annexed the order, Your Lordship. And I've checked the case status and I've annexed them. And Your Lordship, in the supplementary report, Your Lordship.
Machinery is with the GST department.
Yes, Lordship. The GST part.
Then
Lordship, if the specific order be given on the GST department.
it can't be. I don't know what case is pending there. The difficulty is we don't know what is exactly there. If you are, it's a vehicle.
Lordship, it's an excavator.
Excavator. Maybe that is, I don't know what is the reason.
Your Lordship, I have annexed the photographs. It is on page number 36 in the main report. I went to the site, Your Lordship, and I have tagged, I have did the whole thing with the support of the geotag application.
So the excavator is there.
And Your Lordship, in page number 38, I have visited the GST office. Your Lordship, in the supplementary report, in page number 7, Your Lordship, I have annexed the relevant papers that was given by Manish Dasgupta because he took some time to provide me the relevant papers. When I visited his office, I requested him to give me some sort of relevant papers or documents. So he provided me with all these papers, Lordship.
You have to move an application for in the circuit bench only for release of the vehicle. I can't pass an order. It's a pending proceeding. You have to move there. You withdraw this with liberty to move there. What can you do? You withdraw it with liberty to move there. Or I'll just give a date, do whatever you have to do. The report of the receiver is taken on record. At the request of the learned counsel of the petitioner, let this matter be listed. I'll keep it after 2 months. Monthly list of July. July. Keep it pending.
Grateful, Your Lordship.
Monthly statement of 39.
My section 9 application, my lord.
Right.
There is one more matter which is item number 94. One is the owner, the other is the company. Now, my lord, these both matters, my lord, are matters where I'm seeking for an interim order because, my lord,
There is already
my
interim order, my lord.
interim order is on the
Hey.
windmills, my lord. That, my lord, he's running the mill and earning, not paying me. But, my lord, I believe he has some difficulty today. I'm not standing in the way.
Chaudhary, my lord, there's a point to be argued here, my lord. It's not a
Yes,
simpliciter.
I will argue it out also, my lord. His claim has been rejected, my lord, in the NCLT because of the CIRP process. Now he cannot reopen that before, my lord. My lord, I'll show the law on that also, and lordship knows, my lord. But, my lord, kindly, my lord, these two matters, if your lordship keeps next week, my lord, I can come back. Because, my lord, this, my lord, either way, it has to be, my lord, satisfied.
Here, my lord, the applications are
connected.
Yes, one is the owner, the
They're
other is the
separate
company.
separate agreements, separate parties, but my lord, same sets of lawyers, my lord,
Same family.
It can be heard
owner,
together.
owner and
Point
the
is the
company.
same.
Point is the same.
The
Identical
agreements are
point,
different.
affidavits complete, everything, my lord.
But my lord, or rather, the entities are different and the agreements are different, but
That
the
has to
point
be.
is the same.
It has to be, my lord. One is the owner in his own name and the other is the company, my
One
lord.
further prayer, my lord, here section 9 has been instituted prior to section 21 notice. In December 25, my lord, the section 21 notice has also been issued by the petitioner. That also, my lord, I'll try to convince my clients if it's possible to have a consent accorded to go to arbitration. My lord will kindly.
I'll be very happy. What happened, my lord, in the first course, they opposed the section 11.
No, that was on
And that was withdrawn, my lord. But now, if he can impress upon his client, I'll be happy.
In
I'll
that
be happy.
prior round of section 11, there's a technical issue with the application. That is why it was withdrawn finally. But regardless, my lord, we'll kindly not record anything. We'll try to. So long as Mr. Banerjee's client is.
So I'll be happy. He had opposed by filing an opposition in that application. I'll be happy if he is agreeable to it, if he can impress upon his client, my lord. So lordship keeps it next week, both the matters. If he can impress upon the client, it can be disposed of then.
So not today.
My lord, if these two matters come together, my lord, for that, my lord,
It could be
I
in the
think
daily list. That would be
in
my
the daily
preference.
list, these two matters, my lord.
That would be easier. If
So that this can be disposed of, my lord.
daily list, if it comes Wednesday, if it commences tomorrow, Wednesday.
Wednesday. 17. Grateful.
You get the instructions so that we don't have.
Yes, yes. I'll be very happy. I tried this. He opposed.
I'll be happy to.
Yes.
I never.
Today, my lord, I was saying.
I'll try my.
My lord, just now I was telling him, my lord, an incident with an arbitration. My lord, lordships are passing an order that the payment would be in terms of the fourth schedule. There is an arbitration appointed by my lord, where my lord, the arbitrator says that each application he'll, my lord, take a separate fee. We have to argue this also.
I have appointed.
Appointed, but now it's not in my lord's domain.
That's right. But
Shocking things that we have to come across every day.
Lawyer
That the main is
gently,
yes. But everybody is, my lord. But the name is all right. This is not in my lord's hand. If these things come out, my lord, it's my lord. It's very difficult to argue out even, my lord, because the schedule does not say anything. It's only for the entire reference. Now, if somebody comes up with this plea, it's dangerous to even argue. That's what I was telling them. And my lord, this domain is becoming a serious, my lord, floodgate for. Yes, I was shocked, my lord. Why I did not go on that day. My junior went. I did not go on that day. My junior went. Somehow he took an adjournment and came back saying that my senior will come and argue. The fact is that this is something shocking. Yes, I from the bar a senior gown. Off, so I can say it. From the bar a senior gown. Great. স্যার করে দিয়েছে তো এটা একসঙ্গে আসবে তো একসঙ্গে but unless the order comes up I can't. I have to get it recorded. I have to lose the matter there.
My lord, this is that MSME Facilitation Council matter, my lord, where my lord has your lordship's order of 4th February 2026, my lord, for a moment. Despite, my lord, directions in civil revision by this court, my lord, the MSME Council is not deciding the matter. Earlier, we had approached Section 9. The court said you try 17 and then come back. So then we filed 17. It was not being taken up. Eventually, my lord passed this order on 4th February. If my lord has the order, this court with a order dated, my lord has not. This court with a order dated 20th January 2026 had adjourned the matter to enable the Facilitation Council to decide the application under Section 17. Learned counsel for the petitioner submits that hearing before the council was conducted. No order was passed till date. Later on, we have got an order where they have gone into merits and asked for documents. Give an opportunity to the other side to give documents. Senior counsel appearing for petitioner has drawn attention to the conduct of learned counsel for respondent. It is submitted that during the proceedings before council, learned counsel for
Where's the respondent?
not here. Now, what has happened is, my lord, we have communicated this order of your lordship on 4th February.
Yes.
Despite that, no date has been fixed by the council, my lord. And if my lord sees the opposition that they have now filed, they have not annexed any of these so-called objection letters. But all those objection letters, my lords, are beyond the statutory period provided under the Act. So, my lord, under the Act,
that is for them to see. That's not for me to see.
Let them decide by Section 17, my lord. There are this court, 3 orders of this Honorable High Court, my lord. They are ignoring like this. Later, my lord may fix a date, my lord. Let them decide the application under Section 17. How can they ignore? We have communicated the Honorable High Court's order to the council. There is no date fixed even. On 6th February, we have communicated the order. Civil revision, there was an earlier order which is also on record.
He has filed his affidavit in opposition here.
Yes. On merits, he has given his stand. Now, kindly see, my lord, the order passed by this court in writ petition. Kindly have my supplementary affidavit at page 6.
Oh, that is already recorded.
Yes, it is recorded. So, I am only submitting, my lord, that he has given a stand on merits. I am, according to me, in terms of the Supreme Court's judgment, where 17 is not efficacious, 9 is maintainable. Now, either, my lord, with the greatest of respect, either my lord may take up my Section 9, or else if my lord is not inclined to do that, my lord may at least let the council hear my 17 fix it on a date and hear my 17. They are not even fixing a date, my lord. In 2025, 27th August, there was a direction to dispose of within the statutory framework. 90 days from 27th August 2025. It is long expired. If High Court orders, my lord, why subordinate authorities are not ignoring High Court orders, my lord? How can this be?
Where's the other side?
Yeah, they are not appearing, my lord.
Not appearing means?
I mean, they are not appearing today, my lord.
We'll have it day after. Friday.
Fine.
Keep it for Friday. Or keep it for Monday. Monday.
No.
41. Monthly statute number 41.
Dismiss for default.
Forty-two.
May it please your lordship, my lord, 42 is my section 9 application. My lord, the disputes related to a construction of a laboratory. My lord, your lordship had passed an order appointing a receiver.
Receiver to
Yes, my
somewhere
lord.
in Himachal or something.
Yes, my lord, receiver circulated the report. It has also been filed in court. Now, my lord, the parties are before the MSME council, my lord. My lord, they are trying to, my lord, the arbitration is ongoing there. So they
then-
have filed their statement of claim. We are yet to file our defense, my lord.
So
My lord,
you take
nothing.
this is not pending. You withdraw this.
Yes,
Learned counsel for the petitioner seeks to withdraw the present petition. The same is.
my lord, this has become infructuous.
This
My
is
lord,
bec-
the
so that's
prayers
why
have
I'm
been
saying-
granted by your lord. Yes,
That's what I'm saying.
yes, my lord.
Seeks to withdraw the present petition. The same is dismissed as withdrawn. Why should I say infructuous?
Because, my lord, the prayers.
Whatever you have to file before the council. Section 9 also, if you want to. The receiver has already been appointed. He has already prepared probably a
report, yes.
report. So if you want any further relief, file a section 9 before the arbitrator, before the council. The matter is before the council, right?
Matter is before the council.
Nothing is here.
Very well. My lord, may I pray for this? My lord, may a copy of the report be sent to the council? My lord, or we should.
You can always file a copy
Yes.
of the report before the council.
I'm grateful, ma'am.
If you want, I can just add one line. Learned counsel for the petitioner submits that the matter is already pending before the council. What is that council?
My lord, the MSME council, my lord, at
Must be somewhere else.
my lord, Meerut.
At Meerut.
Meerut, my lord.
MEERUT.
RUT, yes, my lord.
At Meerut. Council of in view of the same, the present section 9, the present petition has become infructuous. The petitioner is at liberty to file appropriate proceedings in accordance with law before the council. In view of the same, the present petition is dismissed as infructuous.
I'm deeply honored. Great.
Forty-three.
Lordship, I'm praying for a very short Passover. My counsel is on his legs in court 32. Lordship.
Passover not possible, not today.
Forty-four.
File the gun. Dismiss for default. Dismiss for default.
Minus 45.
Why you're not appearing in 44? You are in 45. Why you're not appearing in 44? That is also yours. Sir, you appear in from the office of
My lord,
45, my lord.
your junior of whom?
my lord, I am appearing online, my lord. 45, item number 45.
Archana Chaudhary. Are you appearing from the office of Archana
No,
Chaudhary?
my lord, I am for respondent number 2 in 45.
Respond number 2. You are appearing
Yes,
for
ma'am.
Respondent number 2.
respondent. That's
Yes,
what I'm
ma'am.
saying. Why you are appearing on this side?
Pardon, my lord.
Dismiss for default. Now,
नामটা দেবেন তো 45
इसको भी लेके जाओ rear row. Next.
46 46
Dismiss for default.
Obliged, my lord.
Item now 46
Dismiss for default.
তিনটে রিসিভ 45 শুধু রেসপন্ডেন্ট নাম্বার একজন 47
My lords, my learned friend, that in this case, this is that matter, my lord, where the PAN card, my lord, there was attachment to the extent of the amount in the award.
Yes.
They have filed an application raising a point of territorial jurisdiction. My lord, my learned friend submitted on the last occasion that the agreement, my lord, was executed within the jurisdiction of the Alipur court. And therefore, my lord, this honorable court on its original side does not have jurisdiction. My lord, I had to address, my lord, on the point that has been raised by them. So,
Directed my learned senior to file the opposition to like user reply, come up with such documents which we need to address. So without
opposition is not on
putting
record.
that stand on affidavit,
I'll handing over.
Lordship will give us 1 week to file the reply. Time.
Affidavit in opposition filed by the petitioner. The other petitioner.
Yes, ma'am.
Petitioner is taken on record. Reply to the said affidavit in opposition to be filed by respondent seeks and is granted 2 weeks time. 2 weeks.
1 week, There's some impending urgency, which is why.
In his application, he had fairly made, my lord.
In fact,
Let him secure the amount, my lord. Let the attachment be released.
then I will address your lordship.
No, I am ready to respond. Even without affidavit, I can argue the matter.
To showcase our bonus.
You need 1 week, 2 weeks.
1 week, your lordship.
Takes 1 week to file his reply to the said affidavit in opposition. List after 3 weeks.
Most great.
GA, order GA में.
Lordship, in fact, I reprimand myself for doing this, Lordship, on instructions. I'm not supposed to mention at this hour. My advocate on record tells me for item number 33, perhaps the Lordship has dismissed it for default. May I just humbly pray, your Lordship, if we can come back on Friday. I apologize. In fact, 33 of the monthly list, your Lordship. I absolutely apologize.
You are appearing for Durgapur Steel.
Durga, it was our section 11, your Lordship. In fact, on the last occasion we were there, the respondents were not there because of the.
All right, 33. Yeah.
I'm so. I apologize at the same time.
this week
Not today. 33 not today कर दो रिया को बताओ.
I appeal for the respondent now. For the petition. আমাদের website এ।
May I file the reply one?
Well, there was a direction.
Yeah, filed reply to?
Yes, my lord, I have filed.
Yes, to our opposition.
Yeah. On the 6th January, your lordship has passed the order, my lord, an interim order, whereby your lordship is directed not to sell, dispose, or transfer the property, which is, my lord, the asset which is under the custody of the respondent company. And that was valid, my lord, for the 3 months. My lord, that has already been expired. My lord, I think, my lord, that is there. And my lord, in opposition, it appears, my lord, they disclose
My lord, at the threshold manner, I'll say that this application has become infructuous
that's what
as we have filed a application before the DRT, my lord, being the asset, the same asset, my lord, for the same asset. So this application has become infructuous, and on
lord,
6th,
this-
my lord, the direction was that if they pay the amount, we won't sell the asset, my lord. So we have not sold it, my lord, but we have filed an application before the DRT, my lord, in the meantime. So
Well,
this
that is
application
there-
has become
that is
infructuous, my lord.
Well, that your lordship is aware of this fact that even if the proceedings before the DRT is concerned, Malad, if there is a clause of arbitration in the agreement, though it has not been served upon us, as long as Malad, since the signature has been made by the parties, Malad, the agreement has not been served. But it is appearing from that, Malad, there is a clause of arbitration. So, Malad, your lordship is aware of, Malad, the Supreme Court decisions are there, Malad, the simultaneous process. Maybe don't, Malad. I am not on that, but this is only our Section 9 application. I also think about that. This has now become, because this has not been now become infructuous, but your lordship has already passed the order, and that is for the limited stay of 3 months. That has already gone, Malad. The January is the order, Malad, that has already gone. But I think, Malad, I have to make out another applications, Malad, there also, because they have filed, but the copy has not been served as yet. Malad, so far as the OA is concerned, only it is appearing from their affidavit in opposition. They have filed it, and never ever, I think, Malad, no order, nothing has been reflected from this. Malad, in this stage, Malad, as your lordship so thinks, so whatever, Malad, this Section 9 has, I think also, Malad,
You withdraw the Section 9, nothing is there. The learned counsel for the petition seeks to withdraw the present petition. The same is dismissed as withdrawn, with liberty to file appropriate proceedings in accordance
my
with
lord.
Grateful.
reply affidavit in opposition and reply to the same is taken on record.
Lordship, this is my application. Lordship, there's a section 8 that is pending in this court of Barasat. We still have not heard back regarding the status of the case. I'm praying that this matter be kept in abeyance.
Learned counsel for the petitioner states that the application under Section 8 of the Arbitration and Conciliation Act is still pending before the court at Barasat. She prays for an adjournment. Let this matter be listed in the monthly list of July.
Lord, I'm appearing on behalf of the petitioner. Lord, our leading counsel is from New Delhi and he is unable to appear before your lordship due to some personal reasons. So if we'd be grateful if a further date be granted.
Proxy counsel so and so appears and states that the main arguing counsel is in some personal difficulty. Let this matter be listed in the monthly list of July.
Grateful, my lord.
What is that? Where is the What is left in this matter? This is that TGIF or something.
Yes, yes, my lord.
What is left in this matter now, section 9?
My lord, the order which you had passed where we were supposed to ask them to refrain from using our name and posting on social media, my lord, they are kind of scooting around the order, my lord. My lord. The exact details of which Mr. Khanna would be able to elaborate.
My application under section 9 of the Arbitration Act, my lord, we have effected service twice. And this is pursuant to the last direction, my lord.
Still nobody is here. What is wrong?
Nobody is here for the respondent, my lord, but I should be candid, my lord. When this matter was first placed before your lordship, my lordship had taken the had a particular query whether this court has jurisdiction or not. So I should, my lord, satisfy your lordship on that count. Your lordship, my lord, should I move, my lord?
No, I want to know why they are not appearing. They have not been served or they have been served.
Yes, my lord. This I understand, my lord, this is the third service.
Yes, what is it?
Yes. So lordship will kindly, my lord, take the agreement first, my lord. This is the purchase order that we received from the respondent for supply of goods at page 15, annexure A. The lordship will kindly, my lord, come to page 16. Sorry, page 17 under law and jurisdiction.
Page
17 of the application. The second heading, my lord, law and jurisdiction. But may I place it?
Item number 33.
Yes.
Yes, my lord, perhaps, my lord, this line, the arbitration proceeding shall be conducted in Orissa, my lord, may be troubling your lordship.
Yes.
Lord, I'll only rely on two judgments, my lord, BGS Soma and a judgment of a coordinate bench of this Honorable High Court. Lord, essentially, my lord, since, my lord, BGS Soma in two paragraphs, my lord, essentially, my lord, paragraph 59 and 82. At this stage, my lord, if there is no specific, my lord, if it is not clear whether this is the seat of arbitration or not, whether Orissa is the seat of arbitration or not, then, my lord, at that stage, my lord, section 9 is applicable, maintainable before this Honorable Court, considering that purchase order was received within jurisdiction, and it will be left to the arbitrator to decide the seat of arbitration. But unless that is done, my lord, I can maintain an application under section 9, my lord, in the factions of this case, my lord, before this Honorable Court. Lord, may I rely upon the judgment of the Honorable Supreme Court reported in 2020 2020 volume 4 Supreme Court cases 234. The entire issue is on venue and the seat of arbitration and what are the grounds or what are the considerations to decide whether a court is a seat court or not. Lord, will your lordship kindly take, my lord, paragraph 59 directly? That is page 55, internal page 55. Lord, may I please? But equally incorrect is the finding in Antrix Corporation Limited that Section 42 of the Arbitration and Conciliation Act 1996 would be rendered ineffective and useless. Section 42 is meant to avoid conflicts in jurisdiction of the court by placing the supervisory jurisdiction over all arbitration proceedings in connection with the arbitration on one court exclusively. This is why the section begins with the non-obstante clause and then goes on to say, where, with respect to an arbitration agreement, any application under this part has been made in a court. It is obvious that an application made under this part to a court be a court which has jurisdiction to this application, to hear this application. The subsequent holding of this court that where a seat is designated in the agreement, the courts of the seat alone have jurisdiction would require that all applications under part 1 be made only in a court where the seat is located, and that court alone then has jurisdiction over the arbitral proceedings and all subsequent applications arising out of the arbitration agreement. So read, Section 42 is not rendered ineffective or useless. Also, where it is found on the facts of a particular case that either no seat is designated by agreement or so-called seat is only a convenient venue, then there may be several courts where a part of cause of action arises that may have jurisdiction. This is the line specifically that I'm relying upon. Against an application, again, an application under Section 9 of the Arbitration and Conciliation Act 1996 may be preferred before a court in which part of cause of action arises in a case where parties have not agreed to a seat of arbitration, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under Section 20, subsection 2 of the Arbitration and Conciliation Act. This is essentially what I'm relying upon. Thereafter, Lordship will kindly take paragraph 61. It will thus be seen that wherever there is an express designation of a venue and no designation of an alternate place of seat combined with a supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually seat of arbitration, jurisdictional seat of arbitration. Now there are contrary indicia in this case.
I'll go by this.
No, I that is why, it is my duty to place this. I should not have, avoided this. Why I say this, there are no contrary indicia. Why I say this, both the parties are from West Bengal. These supplies were made in West Bengal. The respondent had a contract in Orissa, and for such reason, my supplies were also made in within West Bengal. And thereafter, he might have used those the goods somewhere for a project in Orissa. So the parties, part of the entire cause of action in the first case has arisen within jurisdiction, within at least West Bengal. Firstly, and secondly, there is no other reason why the parties would have chosen Orissa as a seat of arbitration. That is why I rely upon, I'll go back to paragraph 59, the last few lines. May I just place it once again, Yes. Again, an application under Section 9 of the Arbitration and Conciliation Act may be preferred before a court in which part of cause of action arises in a case where parties have not agreed on a seat of arbitration, and before a seat may have been determined on the facts of the particular case by the arbitral tribunal under Section 20, subsection 2 of the Arbitration and Conciliation Act 1996. Yes. The invoices were also issued from within jurisdiction. Invoices were received, that also within jurisdiction, I mean within West Bengal, and then I'll come to why Kolkata, why this Honorable High Court. So therefore, my lord, there is no reason why the parties would have chosen Orissa to be the seat of arbitration.
There can be, sir. You can read further. There are cases
Correct, my lord.
where...
The other parts are where there are...
No, I'm not convinced. I will read the seat venue as the seat of the arbitration. You have to go to Orissa. If you want a dismissal, I'll give you.
But may I only place another judgment by our Honorable High Court, my lord, the coordinate bench, my lord? If your lordship is not with me, my lord, I'll pray for withdrawal. It is not in my humble submission, my lord, going by paragraph 59, 61, and later, my lord, 82. It is not in all cases that the seat is determined, the venue is automatically designated as a seat, or is considered to be a seat even at a section 9 stage.
I would go a step further and say you have chosen a neutral venue.
Neutral venue, look, that is what I'm on. But that neutral venue may not be a seat of arbitration. That is what I'm on.
Neutral venue can be the seat of arbitration
Look,
in
that
terms
is
of judgment pronounced by the Supreme Court.
that is subject to determination of the arbitrator under section 20, subsection 2. That is why I relied upon paragraph 59.
Sorry, sir. Anyway, show me the other judgment which you rely
No,
on.
look. No. But this is a judgment of... It's an unreported judgment, my lord. The lordship will kindly will directly take paragraph 15. There is a difference. The clause is slightly different. That this is at internal page 10.
Is different.
Yes.
Your clause is different, sir.
Clause is different, but other than clause, I'll just rely upon the ratio of the judgment, not the clause. The respondent's objection that the clause is vague and lacks necessary particulars to only mean the Calcutta High Court exclusion to the exclusion of all other courts in the city of Kolkata merits consideration. It is correct that many of such clauses suffer from such a generalized brushstroke to broadly include any court within the given territorial jurisdiction. May I pause here for a moment, Millard? Had it been a case where Bhubaneswar or a particular different court had been designated, Millard, I could have easily gone there, and that would indefinitely would have been the seat of arbitration. May have been. But here, Millard, it only says Orissa. It does not even designate a particular court, say a court in Kolkata or Rajarhat or Alipur, as in West Bengal, to be the exclusive jurisdiction. The entire of Orissa, Millard, cannot perhaps have exclusive jurisdiction over the matter. Then I would not know which court to approach.
You see page 13 of the same judgment. The interplay,
page 13.
between Page 13 of the judgment which you are reading. The interplay between seat and venue was reiterated in Soma, where the Supreme Court held that the cases where the parties have not defined the seat, the venue agreed upon would be constituted as the seat.
Yes, my lord, I would have relied upon this. The interplay between seat and venue was reiterated in BGS Soma.
So, sir, in that view of the fact, go to Orissa.
No, my lord, Lordship will kindly also take, my lord, paragraph 21.
I'm not holding this to be the seat.
No, I'm not,
I'll hold the
I'm
venue
not
as the
praying
seat.
your lordship to hold that this either be a seat
Not
of arbitration.
maintainable.
Because
Not maintainable. You want
Lord,
all.
because my lord,
Yes.
this is why, because my lord, had it been the case where the particular court has been designated, say Kolkata or Bhubaneswar, my lord, I would have understood. Here it only says Odisha. My lord, now I feel also face a difficulty in Odisha going there. Which court in Odisha to be approach? Because no part of cause of action has arisen in Odisha.
Go to the High Court.
There also, my lord, I will have the same issue.
What do you
may
want?
I say
You
this?
want me to
Because
decide it? I'll
for
decide.
one state,
I've heard you. You want me to decide? I'll decide.
Odisha High Court may not have original jurisdiction, but
Whatever it is,
nevertheless, let me take instruction and come back.
When do you want?
No, there is another matter he has. So by that time, if we get the instruction, that is what he's saying.
When?
Today itself, Millard, in few other matters are there. So in case we get instruction, grateful.
Then I'm not recording anything. Not today.
Sorry, don't have instructions. Received instructions to withdraw.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. Affidavit of service taken on record.
And now 52.
$52. Chola Mandalam. Nobody is here. Dismiss for record.
Section 9, my lord. 53, my lord. The respondent, my lord, my learned counsel is in some difficulty, my lord. Can it be kept on Monday, my lord?
Monday.
Monday, my lord said Monday or Friday?
Monday.
Was
The rest of the matter.